ಏನೇನ ಮೀಟಿಂಗ್ ಇಟ್ಟಿದ್ದಾರೆ, ಏನಕ್ಕೆ ಮೀಟಿಂಗ್ ಇಟ್ಟಿದ್ದಾರೆ? ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಕ್ಕೆ, ಅಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಕ್ಕೆ ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತಿ? ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ನೋಡಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕು. ಸುಮೇರಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ. 230. Just one moment, Mr. Kannada. We'll call out the list.
Serial number 46. Serial number 46. Yes. Yeah, for a petition, 2 weeks.
We inform the respondent. Both of them. ಏನಕ್ಕೆ 2 weeks? ಏನಕ್ಕೆ?
Serial is not the underline is not the
46. It's submitted that the arguing counsel is unwell and has a 2-week time sought for. Relist on 12th December.
Serial number 59, my lords. Speak for post vacation, my lords. I'll file objections.
Yes, Mr. Achappa, now 59. ಏನು
59 ಅಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ ಸ್ವಾಮಿ after winter vacations.
ಏನಕ್ಕೆ?
Objections
You're already in the vacation mood. It's still long way off.
No, my lords. We need to get instructions and file objections. It might take 2 weeks to get instructions itself.
2 weeks is this side of the vacation, Mr. Achappa.
Alla,
Okay. November.
3 weeks, my lords.
That also is this side. The Red Council for Respondent number 2 seeks for and is granted 3 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 11th December 2023. Failing it, it will be taken as not filed. Relist on 15th December.
Highly objections.
50? Who is appearing now for the petitioner? The name of the council. Idallu baribeku. 57. Learned counsel for the petitioner has filed a memo dated 17th November 2023, signed by the counsel for the petitioner. stating that the above petition has been rendered infructuous in view of the amendment to the BBMP Act 2020 on 10th March 2023. Accepting the said memo and the submission of the Land Council for the petitioner, the petition is dismissed as infructuous. You are Pawan Shah. You are Pawan Shah. You are Pawan Shah. Shri Pawan Shah has entered appearance for the petitioner. Delete the name of Shri S. Sudarshan as that appearing for the petitioner. Yes. A moment. 66 and 67. 66 same order. Adರಲ್ಲಿ put it Sudarshan ಬೇಡ. 66 same order. 66.
Number 71.
Hmm.
Petition of paper short copy.
Have you informed the respondents? Why do you want accommodation? Even at the request of the council for the petition relist on 11th December. Hmm. He is not a state party. There's some endorsement by the office. Why do you want time? Have the objections been filed? The counsel for the petitioner seeks for a short accommodation. Objections are yet to be filed. 2 weeks' time is granted to the respondents to file their statement of objections, which will be filed on or before 8th December 2023, relist on 10th December. Interim order earlier granted in
Milord,
yes.
Milord, one submission, Milord. CL number
Yes.
25, Milord. I am for petition. CL number 25, Milord.
Please
I am
wait,
for
that is
petitioner.
not been called out. It's not for mentioning. 47. 47, you know. Who are you for? Have you informed the respondents? All of them. Contesting Allah, there are 5 councils. Have you informed all of them? ಬೇಡ ವೆಯ್ಟ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಹೇಳ್ಬೇಕು ಇಬ್ಬರಿಗೆ ಅಲ್ಲ ನೋಡಿ if you have not informed everybody you can't mention Mr. Counsel. Please read the first point in the cause list. They don't need to come and wait because you will take your time and go away. Please wait, we are not adjourning. One memo. Pending matter or fresh matter? Pending matter or fresh matter? In urgency. Now you're, but it come in this natural course. Third.
Order serial number 1.
Jagdisha, you're appearing for Ms. Jagdish. File some documents. Have the copy beforehand. GSTN is of somebody else. GSTN is of somebody else. Learned Council, learned HCGP has filed a memo dated 2/11/2023 enclosing documents. The same is taken on record. Counsel for the petitioner seeks for and is granted 2 weeks' time to obtain instruction, make a submission, relist on 12th December. Pawan Kumar. Ashok. Shivramu. Non-amendment. Ashok. Carry out amendment, serve a copy, pass over. First you do this, then we. यार वो कलर तो what is this compliance of office objection on wakalat? Who has not filed wakalat properly? Some problem on wakalat, yaar wakalat.
Serial number 12, my lords.
Or Mr. Acharya.
My serial number 12, my lords.
Not your matter, it is fourth matter going on. We are
Please,
not
sorry. I'm deeply sorry.
यार दमन. Office objection raised on wakalatnama. Counsel for the petitioner seeks for and is granted 2 weeks' time to comply with the office objection. Madam, you have filed your objections? Namita Mahesh, you have filed your objections? Main bill.
Taxes which they are levied, Indian taxes levied for the hostel complex is part of the college.
It is part of college.
It's a nursing college with a nursing hostel. Medical college with a medical.
What are the items for which you want to levy tax? Which?
These are not for charitable purposes. Exemption under section 110 will not be claimed by them.
Hostel,
Yes.
parking, animal room.
It's not all this. It's based 32 lakhs. Only one.
Just a minute, let us ask them what they want to levy tax on. Yes.
It starts from page 34, hospital building,
Hmm.
parking, doctor hospital first block. Parking, doctor hospital second block, parking, nursing hospital, parking, animal room, college division. Parking.
College division parking, Andre, what does that mean? One is for doctors, hospital building.
Yes. College
Parking.
College without the parking.
Now, hospital, you are seeking for exemption.
It's hospital. Building, yes, hospital building, they'll have, because hospital is a part of the education, it's a medical college.
It may be part of education. You are charging fees or are you not charging fees? Then it won't be exempt. Whatever it is, if you are giving free service on the ground of hospital,
basic challenge is only pertaining to B, 1, 3, and 5. Page
Ravi
32.
Mr. Ravi Shankar, we are one by one we are looking.
Process.
Hospital building is a separate hospital where you are rendering services and you are charging.
Hospital is paid.
You are not seeking exemption.
We are seeking an exemption for this is an element.
That is what we are doing.
Please,
It's a, you have paid taxes, but you are seeking for exemption.
exemption.
Which you may not be, no, this parking.
1,
What is 1, 3, and 5?
yes. Doctor hostel was blocked.
Yes.
Doctor hostel second block and nursing hostel.
Now, this doctor hostel is for which doctors?
But the doctors of the doctor hostel is pertaining to the medical college. So they are the faculty members of the medical college.
What document have you produced for that?
But if you don't have anything else, other than the medical complex in the time.
No, are these for doctors who are engaged in the hospital or are they teaching faculty?
All the doctors who are working in the hospital are also the professors in the lecturers, professors and assistant professors in the medical college.
You will have to place that on record.
And make one.
Yes.
You show from. Not be 94, page number 37. Last paragraph, objections if any with regard to tax set for the case. You are directed to submission page. You are based on 22nd document. And then even.
You not replied to this? There's no order passed. There's no order passed.
So the demand itself is being made, but there is no hospital meeting.
Yes, but you have not placed anything on record here, nor are you replying.
I cannot have this part next week, so I notice all the documents so that this is an
Yes.
integrated complex.
So hospital building, parking is what?
But parking is what is about the college building.
Is it for the student or is it for the hospital?
Nursing hostels parking. If you're not sure in the same paragraph.
So Ravi Shankar, we are asking you a few questions. Please answer those questions. Is this parking for the hospital or for the students?
This is a hospital, this is parking meant for the hostel and the students. There is another parking which is at serial base.
There are two
that is the
parkings.
hospital parking.
There are two parkings here.
3 parkings. At page 31.
There are three parkings.
Yes, page 31, there is a parking for the hospital.
And so there's fourth parking. That is
Yes.
college division is separated out.
Yes.
The
There are
other three car parking is for what?
2, then 3 and 6 are the parkings for the students and the faculty. Serial number 2 is the parking for the hospital. Yeah, you might notice at page 31. Serial number 2 is parking for the hospital. 3, 4 and 6 are the parking for the faculty and students.
You place it on record, let us see.
Please. I should-
But if it requires any disputed question, then you won't get it. It has to be clear on the face of it.
I should do it.
Counsel for the petitioner seeks for and is granted
Next week.
a week's time to place on record documents to evidence that the areas as regards which the tax is now proposed to be computed is exclusively used for educational purposes.
Right.
Citation. Then
I will check it.
Obviously, they have to give you a copy.
permission advance.
ಇವಾಗಲೇ ಕೊಟ್ಬಿಡ್ರಿ ಸರ್. This on 8 December. Pass over for R4 LRs file ಮಾಡಿ. Both the matters, sir. First matter ಅಲ್ಲಿ has been allowed, second matter you have now entered appearance. The five ಅಲ್ಲಿ counsel for the petition submits that seeks for a week's time to carry out necessary amendment file under cost title 5.1. During the pendency of the above matter, respond number 4 has expired. As such, IA 1 of 2022 has been filed to bring the legal representatives of respond number 4 on record. Shri Varadaraj Avaldar has entered appearance for respond number 4A to I. He has no objection for the said application to be allowed. Objection Baker. He has no objection for IA 1 of 2022 to be allowed. As such, accepting the reasons stated in support of the affidavit and reasons stated in the affidavit in support of IA-1 of 2022. Said application is allowed. Respondent number 4A to I are brought on record as legal representative of respondent number 4. Counsel for the petitioner to carry out necessary amendment and file amended cause title, which shall be so done on or before 1st December. The Vadraj Aravallar seeks for and is granted. Yes, Dinabe. Yes, Dinabe. How long do you want to file objection? 2 weeks time to file a statement of objection. Objections, if any, to be filed on or before 1st December. Relist on 8th December. Respondent number 4.
Yeah.
When was that allowed? When were you brought on record as respondent number 4? IA-1 of 23 has been issued. We had issued notice on IA-1 of 28. It's not been allowed. So, you have no objection for IA-1 of 23 to be allowed. IA-1 of 23 has been filed. Simply Ramanalli Patana Panchayat. Since respondent number 2 has now been upgraded to town panchayat, accepting the reasons stated in support of IA-1 of 2023, said application is allowed. Respondent number 4 is brought, Ramanalli Patana Panchayat is brought on record as respondent number 4. Petitioner Shri so and so. The notice having been issued, Shri Rohit Gowda has entered appearance for proposed respondent number 4. He has no objection for the said application to be allowed. Accepting the reasons, so and so is allowed. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Shri Rohit Gowda seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 8th, relist on 15th. Madam, what about your affidavit? Service. The AGA seeks for and is granted a week's time to file her affidavit, relist on so. Affidavit, we'll take it. Naveen is appearing in this. File ಎಲ್ಲೋ ಇತ್ತು ಇಲ್ಲೇ ಇರಕಲ್ಲ ಫೈಲ್ ಮನೆಗೇನು ಹೋಗಲ್ಲ. ಯಾರಿಗೆ your PDOs don't contact you, is it?
Yes.
They don't know how to file. They send it to the Tapal section. There's no page numbering, no annexure, legibility iralla. Why can't they file it through the council? You'll also appear for 3-4. Zilla Panchayat, Executive Officer, DK District Zilla Panchayat. Sharanjit Shetty is directed to accept notice for respondent number 3. Taluk Panchayat here. For R3 and R4. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsel. Despite service having been effected on respondent number 3 and 4, no appearance has been made. Hence, respondent number 3 and 4 are directed to file their affidavits as to what action has been taken post service of summons and why no appearance has been made in the present matter. Respondent number 5 had been directed to file an inspection report while ordered 13/10/2023. The respondent number 5, Panchayat Development Officer has directly sent the said report to the address to this court instead of it being filed through his counsel who has entered appearance. The said report suffers from various discrepancies. As such, learned counsel for respondent number 5 seeks for and is granted 10 days time to comply with all the discrepancies, including furnishing a copy thereof from the counsel for the petitioner and respondent number 6 and other respondents. Released on 14th December. R4. Private party. Right, counsel for the petitioner seeks for, yes, madam? It's service agilala in. Can't take it up until the other matters will take up. This 500 square feet is creating a lot of trouble. What manner to construct is a problem. They don't need a sanction plan. Can they construct any manner? Learned counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application for subservice. Released on 11th December. But we were supposed to file cancellation letter. Naveen, I don't know. That AGA submit that she has to respond number 1. Respond number 1 is not responding. They will respond. Respond number 2, none. When did you send the letter? CCMS alilva deputy commissioner. Email ಕಳಿಸಬಹುದಲ್ಲ. Government advocates have access through the documents through CCMS or no access? That will be provided soon. So once you get your laptops, you will be able to access these documents. That AGA submit that she has written letter twice to respondent number 2. Furnish documents and instruction, however, there is no response. That way of the matter, she seeks for and is granted 2 weeks time to produce the cancellation letter dated 27, original of the cancellation letter dated 27/7/1978. Released on 11th December 2023. If by then the said document is not produced, respondent number 2 shall personally appear a VC. Only when we call, then it comes. It will appear through video conferencing. Why Naveen, you are not filed wakalat? Patients? Mr. Arvind Nawada. Arvind Nawada. Wakalat ಹಾಕೋರ್ಗು dispose ಮಾಡಕ. Counsel for respond number 1, 2, 3 seeks for and is granted a week's time to file his wakalatnama and address arguments. Released on 7th December.
They are not awarded compensation for the marquis. Lordships have already disposed of the matter directly into award of compensation for marquis. Application with the matter came up to the state that they have got.
This is a disposed matter. This is a disposed matter.
there is a mistake submitted to us by us by filing the expedition. The Krishna Gowda, son of Uche Gowda, it should have been mentioned in.
Where is the disclosed order?
12/7.
12/7? 22.
The cross site to the order. Essentially reflecting what is reflected in the cross site to the.
Just one, just one.
Okay.
What is the error?
Because, error is by us.
Yes, yes.
Krishna Gowda, son of Nanjay Gowda. So Nanjay Gowda is a grandfather. It should have been Uche Gowda. Produce documents along with the IAS. Krishna Gowda is son of Gowda. Compensation has already been partly awarded in my favor. But the compensation was not awarded from the markets for which the artists are given direction.
So cost title needs to be amended.
These,
You filed the amendment application?
because an application to give to rectify the mistake in our cost. And said, 46 to 70% disposed of matter.
The above matter was disposed by order date 12 July 2022. Subsequently, IA 2 of 2023 has been filed, stating that there was a inadvertent mistake in describing the petitioner, inasmuch as the petitioner Ramakrishna Gowda is son of Uche Gowda. And the name of Nanjay Gowda, which has been mentioned in the cost title, is in fact the grandfather of Ramakrishna Gowda. It's on that basis that PDR Ravishankar, the senior counsel, seeks for correction of the cost title in the original writ petition and consequently correction in the order dated 12 July 2020. Having heard the learned senior counsel and being of the opinion that there is some substance in the submission made and there is a inadvertent error which has been committed at the time of filing of the petition, the application is allowed. The counsel for the petitioner is permitted to correct the name of the father of the petitioner as Uche Gowda by deleting the name Nanjay Gowda. Consequently, registry is directed to correct the cost title in the order dated 12 July 2022 and issue a fresh certified copy. IA 2 of 2023 is allowed. What is IA 1 of 23?
That's not for extension of time.
What?
The artists are directed, time bound paid for. For our part of it, not paid for.
In view of the correction now having occurred, it was not possible for respondent number 225 to comply with the order dated 12 July 2022. And the time fixed in the order dated 12 July 2022 is extended by a period of 8 weeks from today. IA 1 of 23 is allowed. So, Acharya,
This is a my lord. Writ of mandamus is sought in the writ petition for.
you are now appearing.
Yes, my lord.
Sri S.K. Acharya has entered appearance for the petitioner. Sri S. Rajshekhar, who had earlier entered appearance for the petitioner, has filed a memo of retirement dated so and so. Since Mr. S.K. Acharya has entered appearance, memo of retirement is accepted. Sri S. Rajshekhar is discharged from the matter. Yes.
I say change of kata, my lord. I am the registered owner of the property by virtue of the sale deed, my lord. Annexure E, my lord.
What is the objection on your wakalatnama?
Wakalat, my lord, because I filed my wakalat.
Signature of petition number 2 does not tally, Mr. Acharya.
My lord, I'll verify, my lord. You'll ask my next week, my lord.
That goes to the root of the matter. You should.
My lord, because I have filed the NOC wakalat, my lord, got it
Yeah,
from
but the earlier wakalat and this wakalat is not matching up. That goes to root of matter. Please give your explanation.
My lord, I will furnish the fresh wakalat of both parties, my lord. You'll ask my have it next week, my lord.
S.K. Acharya seeks for and is granted 10 days time
To file the fresh
receive
wakalat.
objection or file a fresh wakalatnama.
Wakalat.
Released on 8th December.
My lord, could it be earlier to it, my lord?
It won't
Fourth of-
read.
fourth.
Every day there are 100 matters, Mr. Acharya.
My lord, 8th I am not out of station, my lord. Going to Trivandrum.
Illogta everybody. 11th. I mean, now I'll ಬರ್ಬೇಕು ಅನ್ಸುತ್ತೆ.
11th, my lord.
11th.
Please, oblige.
Yes.
Copy served on everybody. They cannot type and file these reports, madam. They cannot type and file it instead of writing. In some matters, only writing is good, so there's no problem. In some matters, the writing is as bad as our writing. If they type it properly, it becomes easier to read. There's the encroachment on the road. Verify in monthly. You were there when the survey was carried out. The superimposition has been made. You cannot encroach a public road. Next week, you'll have to tell us when you'll remove it. If you don't remove it, they'll remove it. It's better that you remove it with care and caution and no damage happens. Or remove ಮಾಡಿದ್ರೆ ಆಮೇಲೆ damage ಆಯ್ತು ಅಂತ ಹೇಳ್ತೀರಾ. Next week we'll have it. You tell us when you will remove it. Inspection report has been filed by learned AGA. Copy thereof served on the counsel for the petitioner and respondents. If you read the report, which has been filed in terms of the order dated 26/10/23, indicates that there is an encroachment of a public road by the respondent number 9 and 10. The counsel for respondent number 9 and 10 seeks for and is granted a week's time to obtain instructions from his clients as to when the encroachment would be removed. Released on 27th December.
December. November or December?
27/12. Is today 27? Working day. 27/11. Sorry, my mistake. What were you to file? What were you directed to file? You taken over in the year 2015. We understand that, but that was long time ago, Mr. Modi. That was 2 years ago. Just one. According to you, the person who were handling the file in the year 2020 has expired. In 2021. 21. Now we are in 2023. There's nobody handling this file after that. Why do you require information from them when you have formed the road? One name say. Building has been demolished.
When this letter, they are asking for us the building plan or Kata extent to Kata building itself. But all those documents are there only. Take the photos and do the inspection.
You did not issue a notification or you just steamrolled? They are unable to understand that, accept that submission because you are the authority, so it is on files, it's not on individual based. If we accept that submission, there will be no end to this. It never will this. So you again, what is your? In charge hospital is now hospitalized. Yeah, officer is hospitalized. Then
what has to be done? Nothing has to be done.
These are property coming within the corporation jurisdiction. So Kata has been issued by you. Taxes have been collected by you. Those are available on your file. Those are available in your computer file. They are accounted for. These are all accounted for, Mr. Modi. Okay, clarity thoroughly, but how long does it take for clarity? We are only trying to resolve the problem that you are facing. All that is available. Please look into it and see if there is, how much was they constructed here. KB Munish Kumar, Learned Counsel for Respond number 2. Submit that the concerned officer handling the file has been hospitalized. And in that background, he seeks for and is granted 3 weeks time to verify the nature of construction put up by the petitioner, the extent of construction demolished while forming a road, the extent of TDR amenable for such constructed area demolished, as also the extent of TDR amenable for the area on which the road has been formed.
Otherwise, we would have ended up paying 3 times more spot tax.
You have your taxpayer receipt.
Exactly. I think cross-examine. What happens is public.
We understand that, we appreciate that, you take all your precautions. But those precautions don't need 6 months.
I mean, you will hasten this up, please, as fast.
We list on 11th December. You take out your property tax paid receipt, you will know what is the area, and that's it. They cannot dispute that. It's not the dispute about the ownership, it is
Because of this peculiar situation, we are requesting to give us the document.
tax paid receipt. Counsel for the petitioner is also directed to furnish copy of the tax paid receipt.
As per our communication, then let them give it.
ಏನೇನ್ ಬೇಕು ನಿಮ್ communication ಏನು? What do you want? What are documents sought for?
This letter is.
Documents are very much available.
You seriously want all these documents?
What is this?
Please read your letter. Why do you require all these things? Survey number 327 ಮತ್ತು survey number 328 survey sketch. Survey number 327 ಮತ್ತು survey number 328 BBMP ಖಾತಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆ. ಕಟ್ಟಡದ ಮಂಜೂರಾತಿ ನಕ್ಷೆ ನಿಮ್ಮ ಹತ್ರ ಇದೆ.
Sanction and these are all new areas that are coming to the. State of media, what.
2007 ರಿಂದ ಈವರೆಗೆ BBMP ನೋಂದಾಯಿ ಮಾಡಿರುವ ಕಂದಾಯ ರಶೀದಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆ. 2007 ಇಂದ it came into BBMP jurisdiction. You don't have access to your own taxpayer receipts. Is it not in your computer system, Mr. Manish?
I will ask her.
It is not individual centric. This is only to delay the matter, that's all. ಬೆಸ್ಕಾಂ RR ಸಂಖ್ಯೆ ದಾಖಲೆಗಳು RR ನಂಬರ್ ಏನಕ್ಕೆ ಬೇಕು ನಿಮಗೆ? What will you do with the RR number? Please tell us.
Media issues.
What will you do? RR number 1, 2, 3, 4, 5, 6, 7, 8, 9 and quattro. What will you do with that number? There's nothing you can do with that number. BWSSB in the Samparka Padeyura Dakile. What a connection in the, how will you decide TDR? That you ask for, that you have asked for the plan sanction, no problem. Property tax receipt, which you already have, okay, you are asking them, no problem. Why do you want BESCOM, BWSSB? You want photographs? Ondralli somebody created some fake document or something, does not mean everybody is painted with the same brush. 2015, you have taken the land and formed the road, and we are in 2023, you are not issuing the TDR. 8 years does it take for your officers to do this? We are not able to understand your 8-year delay and giving these kind of reasons and issuing this kind of letter. There has to be some sense in it, and there's some limits in things. A person has lost his land. You have taken away the land, made the road, and you don't want to give anything for that. BBMP is there only to protect the interest of the citizens, not to harass the citizens. And if this kind of letters are being issued, that means your officer only wants to delay it for what purpose? You are the plan sanction? I think plan sanction idea ನಿಮ್ಮ ಹತ್ರ? Copy ಇದೆಯಾ? ಅಲ್ಲ ಅವ್ರ ಮೇಲೆ ಕೊಟ್ಟ ಮೇಲೆ ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಂಡಲ್ವೇನ್ರಿ? ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? Then what is that? That's first. You should have said that first. ಇನ್ನೇನಪ್ಪ? ಇನ್ನೇನಪ್ಪ? If he has already said he is not bothered about the building, we are barking up the wrong tree with all these things. None of these are required. None of these are required. The counsel for the petitioner submits. Though a letter dated 7/10/2023 has now been received by the petitioner, the same has no relevance for the matter inasmuch as 30th October 23. 30th October. The same has no relevance for the present matter inasmuch as the petitioner is not claiming any TDR in respect of the building, but is claiming only in respect of the land. And as such, there would be no requirement. You come up with your calculation at least. Does it take 8 years for a calculation? If you are giving less, they will challenge it. But first do something. This atrocious of 8 years. They have to work. Let them pass an order, Mr. Carson. We are not deciding how much it is, not the civil code.
Not claiming any TDR in respect of the building.
Building demolished, but only restricts its claim to the land used by the respondent, number 2, for formation of a road. As such, the earlier submission made by Shri K.V. Monish Kumar in respect of calculation of TDR for building demolished would not arise. All the documents relating to the property being available with respondent number 2, including the extent of land used for formation of the road. Respondent number 2, in my considered opinion, could not have delayed the matter by a period of 8 years, as regards which necessary orders would have to be passed. Shri Manish Kumar seeks for and is granted 2 weeks' time. It's actually tomorrow you should give it. Adike 2 weeks kodtare. 2 weeks' time to make a submission on the TDR, which will be available to the petitioner. Released on 4th, released on 7th December. The amendment application. No objection in copy banta. Have you received the copy? The counsel for the respondent confirm receipt of copy of IA-1 of 2023. As such, the office objection raised stands complied with. IA-1 of 2023 has been filed for amendment of the petitioner to include a prayer to quash The order passed by the first respondent at 5/11/2022, which the petitioner was not aware of when the petitioner had filed the above petition. Accepting the said reason, IA 1 of 2023 is allowed. The petitioner is permitted to amend the petition and file amended petition, which shall be so done on or before 1st December 2023. Additional objections, if any, by response to be filed on or before 11th December, released on 15th December. Yes. Interim order earlier granted is extended.
I am for the third respondent, my lords.
Yes, Mr. Jagdishwara.
I may permitted to file a fresh wakalat, my lord, because the earlier wakalat doesn't have signature by mistake. I may permitted to file wakalat, my lords. I'll file it by tomorrow itself.
Accepting the reasons stated in support of IA 1 of 2022, the production of certified copy of Annexure K is dispensed with, subject to any serious objection raised by the respondents. Then counsel for respondent number 361 is granted a week's time to file a fresh wakalatnama, relist on 7th December.
Oblige, my lords.
Yes. There's some affidavit was to be filed. Has to be an affidavit filed by respondent number 3 as regard non-appearance. ನೀವು ಹಾಕ್ಬೇಕು ಅಂತಿದ್ದು ನೀವು ಹಾಕಿಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು ಹಾಕ್ಬೇಕು ಇರೋದು ಹಾಕಿಲ್ಲ. Correct again. Hello, you were directed to accept notice last time and directed to do that. Shri V. Gangadharappa seeks for and is granted 2 weeks time to file a statement of objection as also to comply with para 3 of the order dated 25/10/2023. Interim order, said objections to be filed on or before 8th December. Interim order earlier granted is extended till next date of hearing, released on 14th December. Your plan sanction ಆಗಿದೆಯಾ? ಅಲ್ಲ, he has applied for a new plan that has been sanctioned. Yes. Correct. The violation could have to be marked and they have to remove it. So when will you file it? That counsel for respondent number 1, 2, 3 submit that inspection has been carried out. However, since the PDO had been transferred, the demarcation of any deviation and the sanction of the plan could not be done. He seeks for and is granted 10 days time to do the needful. Relist on 7th December. Yes. You have received the petition and the copies? You have received? Naik, you have not received. On behalf of the counsel for respondent number 9 to 15, a week's accommodation is sought for to comply with the office objection raised on the wakalatnama. She confirms receipt of the petition and annexures thereto and seeks for 2 weeks time to file her statement of objections. Shri Yogesh Naik, Clerk Counsel for respondent number 17, submit that he has not received copy of the petition along with annexures. Madam. Clerk Counsel for the petitioner has served a copy of the petition along with annexures on Shri Yogesh Naik. who seeks fund is granted 2 weeks time to file a statement of objection. Objections, if any, by 8, relist on 14. Petitioner, there is no violation. Respondent, 18%. So that
He was respected in the year 1955.
the petitioner is 2005 sanctioned plan.
Alteration ಮಾಡ್ಕೊಂಡು plan.
2005, 2013 in Munche. What about respondent? No plan sanction. What have you done? E56, 248, 1 will there, 356 you will. You are issuing or you have issued? When? Enclose that also along with this. Chaitravati. This is a very old house. This old house until Supreme Court passes orders, that maybe is within that percentage. If it's more than that percentage, we would have. So far as respondent, no plan sanction only, so everything is violated. The Chaitravati BS, Learned Counsel for Respondent number 1 and 2 has filed the compliance report, posing the inspection report and the violations, if any, committed by the petitioner and respondent number 3. The review of the report, insofar as the petitioner is concerned, indicates that the construction of the petitioner has been put up long ago. However, there is a violation and setback in coverage area by 18.5%. The said violation probably can be compounded in terms of the Akrama Sakrama scheme, which is now pending for consideration before the Honorable Supreme Court. That view of the matter, action as against the petitioner is deferred till the orders of the Honorable Apex Court. Insofar as respondent number 4 is concerned, a report has been filed that there is no plan sanction granted, as also there is no setback provided on all 4 sides. He said construction being in progress would not be covered by the Akrama Sakrama scheme, and as such, Learned Counsel for respondent number 1 and 2 seeks for and is granted a week's time to place on record the notices issued under section 248(1) and 2. Relist, as also if any confirmatory order is passed on the subsection 3 of section 248. Relist on 11th December. 11th December, you can complete all 3. ಎಲ್ಲ ಆಗತ್ತೆ. 248(1) and 2 tomorrow. Counsel for the petitioner seeks for and is granted 2 days time to make payment of necessary process fee. If needful is done, registry is directed to issue notice to answer respondent number 4 returnable by 9th January. Tomorrow, idea? Tomorrow, idea? Any entry? Mr. Prabhu, insufficient address. You have to furnish proper. Seeks for and is granted 2 days time to furnish current and proper address of respondent number 4. Yes. Hmm. Hmm. This stood in the name of Rajshekharaya. Rajshekharaya is your father. Yes. Hmm. Yes.
Charges and other things. And they have paid 27 million and it's a fee. Team officer.
Only their property is planning area Lilwa 95 only. There's no planning authority.
All the property of petitioner, they have reserved mark and CSX are also reserved as per the next 3 mega.
Yes.
From this area, it's survey number 8, tag 8 is survey number 1 mega.
Survey number 1 ಎಲ್ಲಿ ಬರುತ್ತೆ?
After the road, after the 300 meters from the road to 300 meters.
So your survey boundary is this dark black line,
Yes,
dotted
sir.
line. For survey number
8.
8. Yes.
28 annexation D.
Hmm.
ಇದು ಅದೇ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ ದೇಶಕ್ಕೆ ವಸತಿ ವಿನ್ಯಾಸ ರಾಜಶೇಖರ್ ಮಂಜೂರು ಮಾಡಿದ್ದಾರೆ. ಸದರಿ ಪ್ರದೇಶಕ್ಕೆ 20/9/95 ವಾಸಯೋಗ್ಯಕ್ಕೆ 3 ಎಕರೆ ಭೂಪರಿವರ್ತನೆ ಆಗಿರುತ್ತದೆ. Annexure E mega, 33.
Yes.
The government, the Deputy Commissioner Tumakuru, sanctioned 6 acres to the KSRTC budget in Gang area. 2 acres for the EAPCLS. To the private question 3 acres. Nirmiti Kendra 1 acre 30 acres. ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆ ನಿಮ್ಮ ಕಚೇರಿ ನಿಮ್ಮ ಕೈ 1 acre.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ?
ಸರ್ವೆ ನಂಬರ್ ಟ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆರೆ.
ಕೆರೆ ಅಲ್ಲ.
ಹೌದು ಇದು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಇದು
ನೀವ್ ಯಾರಿಗೆ? Number? You are the one who sanctioned in the lake tank. How can you do that for the tank? Buffer zone. Okay, by it also now they can't be construction.
there to buy property.
Yes.
From the road. And after the road, also tank is existing.
But now that tank has been that area. This area which is there after the road, you have allotted to 13 acres, 30 guntas have been allotted to various people by denotify. You'll have to take a stand, madam. That if there is a tank, then this 13.30 acres that you allotted to various people will have to go. And whatever you have constructed thereon will have to be demolished.
Saying that how it is back because of the buffer zone. It's not possible.
How is it in the buffer zone?
30 meters from the tank, existing tank. The road also tank is existing, still existing.
Is there measurement illa? Give us a measurement. Give us a measurement as to what it is, but from looking at this X-ray, it doesn't appear to be within 30 meters. Because you will have to exclude this BL 4321. So if we exclude, it will have to be taken into consideration from the road. What is the distance from the road to the property of the petitioner?
Even up the road, some tank is.
You've denotified it.
Some road has been denotified.
So your building will also have to go. We'll give you time, but please be sure of what you are saying. If you already denotified to 13, whether that is, where is that lake still present? Can that lake be present after the building?
After the building. There is a speed of building.
Ideal situation ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. That AGA 6 fund is granted 2 weeks time. 3 weeks time. 3 weeks actually. 3 weeks time to file a statement of objection, including a sketch, detailed sketch of survey number 8 as also survey number 1 of Kasba Hubli, Tiptur Taluk. Said sketch to also depict the exact location of the buildings which have been allotted, buildings constructed in terms of the allotment made by Annexure E dated 18/4/2005 to the distance of the property of the petitioner from the road which has been constructed on the lake. If there is any area denoted as lake after in survey number 1, after the construction, which has been put up, the exact location of the same. There are objections to be filed on or before 11th December 23, relist on 14th December. Interim order.
That's why I'm saying.
Ah,
Wait, it's not the, as per the next real one.
no, don't carry on any work. Don't carry on any work until this gets resolved. ಇಲ್ಲ ನೀವು work carry out ಮಾಡ್ಬಿಟ್ಟು demolish ಮಾಡ್ಬೇಕಂದ್ರೆ you lose out on money. Don't carry out any work. Again and again, we'll resolve the matter, but don't carry on construction. I will demolish ಮಾಡಿದ್ರೆ why do you want to invest money? Yes. What are the objections? Yes, what is Annexure J? Your challenge Annexure J. Office objection is that you are not produced a certified copy.
That's the only thing that is a certificate. That's why I have filed. Otherwise, I will have to file the application part of the.
Counsel for the petitioner submit that Annexure J is as received by the petitioner, which bears the seal of respondent number 2. For now, the office objection are kept in suspension, subject to any objection, serious objection raised as regard the veracity by respondent number 1 to 4. Yes, what is this? What a deed of sale. TDS Karthikeyan seeks for and is granted 2 weeks. Copy has been received. TDS Karthikeyan confirms receipt of a copy of the petition along with annexure. He seeks for and is granted 2 weeks time to obtain instruction and make a submission. Relist on 11th December. Interim order earlier. Idea.
Not it.
Where is the interim order? Interim order earlier granted is extended till next. On amendment, Mr. Good afternoon. This is which one? That restaurant.
In the residential locality.
Hmm.
The shops are not there as per the conditions. That's where we got these drivers complaints. And in this case, what is under challenge before we got is Annexure E. Annexure E, the basement portion lot, they were conducting where it was specified specifically for the purpose of stop.
That they filed the undertaking that they won't use it. Yes.
But subsequently, your lordship permitted them to file a fresh application.
Hmm.
That application is also rejected. Consequently, there is no trade license for them to go on. Now, not they without amending this to the player. Now just now they are commissioning a copy of this. It may not
Let him finish his submission, then you can make. Otherwise, neither he will finish nor you will finish.
Now that they have published a copy of this application, amendment of additional.
You filed amendment of.
To challenging, this particular order also passed by me.
Hmm.
But I take instructions in so far as this aspect is concerned. Let this application be allowed. Comprehensive will be set. Now, not based on the big prayers, I have secured instructions. In so far as the additional prayer, what they are now asking, but I have to secure the papers.
In so far as the writ prayers, what is the thing?
Writ prayer is your cost actually. Actually, he is only a notice. And see actually page 30.
Stopping work.
No, not stopping work. Not basement portion. They were conducting kitchen activities. This
Now, where is the amendment application?
amendment application is rejection of the application subsequently filed pursuant to the direction of your office. Not for an additional prayer, absolutely no problem. I take further instructions in so far as this aspect is.
There's some other amendment that you're not carried out is what the office note is. What is that amendment?
Probably your lordship brought on the last date had directed them to carry out this amendment. The same pertaining to what now they are filing application. Are they there?
Counsel for the petitioner is filed. How can you file it under 151, Mr. Shantibhushan? You have to file it under 6 rule 17 and you have to not, you have to make out grounds as to why you want to amend. ಏನು ಇಲ್ಲ ಇದರಲ್ಲಿ. There's nothing in this application. File it. ಸರಿ ಇಲ್ಲ ಇದು. You can't allow, even allowing this won't help you. Even allowing it won't help you. Pass over. At the request of counsel for the petitioner, released on Monday. Let him file the amendment, then we'll give you time. 21st ನಮ್ಗೆ ಜಾಸ್ತಿ ಇದೆ. We'll allow the amendment on 20th. ಆಮೇಲೆ ನಿಮ್ಗೆ will give you time. You need 2 weeks time.
I'm paying about 250,000.
They've rejected your permit. We'll have to examine that on merits, whether reasons are right or wrong. Earlier the permit was there. Now the permit is on the basis of your permit reject act. We'll have to consider.
My lords, I am for petitioner, my lords.
Yes.
I'm for petitioner, my lords. My lords, kindly have it next week, my lords. A small accommodation, my lords. As per the direction, copy is being served on the government, my lords.
Yes. What is your submission? You're filing your objections. Bhagat? Mallikarjunaya? You also filed. So Mr. Umesh, you are filing now. The AGA? Last time new time to only. Yes. Have you filed your objections? Yes. You were impleaded. Why were you
Application got rejected.
When were respond number 5 to 7 impleted?
Notification of the government was relied upon by the petitioner.
You were impleted on 8/11/2022. How long ago? ಮನೆಲ್ಲ ಹಿಂದೆ ನೋಡ್ತಾ ಇದ್ರೆ 8/11/22. Because your say would be relevant for this. But your stand would be very much relevant. The counsel for respond number 1 and 2 has filed the statement of objection. The same is taken on record. Copy thereof has been served on all the other counsels. You served it on everybody. The others also, everybody is entitled. Copy thereof has been served on the counsel for the petitioner. He is directed to furnish copy thereof on the other counsels for the respondents. Similarly, the other counsels who have filed, other respondents who have filed objections are directed to furnish copies to each other. The SCGB seeks for and is granted 2 weeks' time to file a statement of objection, which shall be filed on or before 8th, relist on 12th.
My lords, interim order to be extended, my lords.
Interim order earlier granted is extended next. 12th. Let's file this application. What is the correction? Para 3. Para 3 alien upper correction, no? Para 3 alien is the correction. Para 3 is only referring to 356. Of the operative portion. The counsel for petitioner is filed I-1 of 2023 for correction of the order dated 10th October 2023. That's which is in line 5 of operative portion Roman 3. The word of petitioner, the word petitioner is to be replaced by respond number 3 and 4. That submission is accepted. The word petitioner is replaced by the word respond number 3 and 4. Registry is direct carry out necessary correction and issue fresh certified copy. Is respond number 3 and 4 in accordance with law by detailing made by respond number 3 and 4. Yeah, only ask for one. It is not page 3. It is page 4. Page 3, para 3, alien correction. No? Replace para 3. The grievance of the petitioner is that demolition order under section 356, as also the earlier notices issued under section 248(1) and 248(2), the confirmatory order under section 248(3), issued by the assistant executive engineer, has not been acted upon by the respondents. And consider opinion that the assistant executive engineer not be so authorized to issue the notice under section 248 of the BBMP Act 2020.
Yes. Hold on.
Ramesh Kumar. matter, Mr. Again? The allotment is in a shop in a CSI. We already, preemptive order has been passed and nobody is appeared. Despite the order date 3/11/2023, none appears to the petition today also. It appears that the petitioner is not interested in prosecuting the matter. The petition is dismissed for non-prosecution. Pending IA also stand dismissed. Yes. Post box. ಇಲ್ಲಿಂದ ಅಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ, ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ. ಒಂದ್ ನಿಮಿಷ, ಇವಾಗ you filed IA4. IA4 you have served with all copies of the documents. You need to file some documents. The counsel for proposed respond number 8 and 9 has served copy of IA4 of 23 on counsel for respond number 2 and 3. You have received it? Counsel for the petitioner confirms having received it earlier. By proposed respond number 9 antiದೆ. You have filed for in pleading respond number 8, that is IA3. And IA4 is filed by you to come on record. What about respond number 6 and 7, which is their application? IA number? Will come to which is the IA to be considered? So there is one single IA filed to implead respond number 5 to 8. Now who has entered appearance for 5? Mr. is served, no appearance. 6 and 7, you are appearing. 8, you have entered appearance. 9, you have filed an application. Yes. So any objections to their application? To IA3? IA4 ನೀವೇ ಬರಬೇಕು ಅಂತ ಹಾಕಿದೀರಾ, ಆಮೇಲೆ objections ಬೇರೆ ಅಂತಿರಲ್ಲ, ಯಾಕೆ? That we will consider later. Any objections to the impleading application? No objection. What about you? No objection. IA number 3 of 2023 has been filed by the petitioner to implead 4 other parties as respond number 5 to 8. Notices having been served. None has entered appearance for respond number 5. He is expert anyway. They take the
Six and 7, but they suit against the father. They have sold the property without
anyway, your father has not appeared.
father.
Either you take the advantage or disadvantage of that.
I can take my own stand.
Respond number Shri Syed Akbar Pasha, learned counsel, who has entered appearance for respond number 6 and 7, proposed respond number 6 and 7, submit that he has no objection for allowing IA3 of 2023. So also the submission of Shri Arsha, who has entered appearance for proposed respond number 8. In view thereof, IA3 of 2023 is allowed. The person named therein are brought on record as respondent number 5 to 8. Counsel for the petitioner to carry out necessary amendment and file amended cost title. What about their application? You have any objection? IA number 4 of 23 has been filed to implead one person as respondent number 9. Counsel for the petitioner submit that she has no objection for said application to be allowed. In that view of the matter, IA 4 of 2023 also stands allowed. Counsel for the petitioner to carry out necessary amendment, file amended cost title. Consolidate Kedagai.
Respondent number 2 or 3.
Road register.
Today I have received the.
What is IA 2 for production of documents filed by petitioner? Any? You have to serve a copy. Whatever it may be, you serve a copy. Counsel for the petitioner undertakes to furnish copy of IA 2 of 2023 to the counsel for respondents. Counsel for respondent number 2 and 3 seeks for and is granted weeks, 10 days time to produce the road register. Relist on 7th December. Relist on 14th December. In the meanwhile, objections to be filed. You have no jurisdiction, you can't excise. You have no idea. On behalf of counsel for respondent number 2, a week's time is sought for on the ground that there is some personal inconvenience. Relist on 8th December. Please, why are you not appearing in this matter? Yes, really.
Taking directly against responsible not to consider an application. Not for the grant of not fitting license law. But it is pending since 2019. Not the authority.
Filed the application in 2019 for plan sanction.
Convention formula.
Yes, madam. Mangalore Urban Development Authority is Gangadhar. A. Ravi Shankar. A. Ravi Shankar is directed to accept notice for respondent number 2. Registry direct print his name as such. Registry is also directed to delete the name of Sri Ashok Naik as that appearing for respondent number 2. Counsel for the petition served 2 sets of the petition along with annexures on Sri A. Ravi Shankar, who is directed to obtain instructions and make a submission as to why the application filed by the petitioner for sanction of plan on 8/11/2019 is still pending. Relist on 14th December. Conditional order hoittu. That's why we are putting it under that caption. Then advocates will come. Otherwise, even then they won't. Pass over. Raviraj.
Okay.
And AG accept notice for respond number 1. Shri A.V. Gangadharappa accepts notice for respond number 2. Shumat. Aso. Aso. In respond number 1 and 2, na? One day, na? AGA for respond number 1. A.V. Gangadharappa for respond number 2. Shumat. Page
99.
short of a century. ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಸೆಂಚುರಿ ಸ್ಕೋರ್ ಮಾಡಿದ್ಮೇಲೆ what is your representation?
But the representation in the context of two documents. What should find out the pay ET and ED. These are two purported khatas, but which will mark in evidence, because I have to exhibit P28 and P29 soup of airmen, and not in the connected soup of specific form. Page 80 and not page 83.
Page
80.
8. Yes.
Basically calling depicting the taxpayer name say Mandani.
The right time you started issuing this Karta certificate digitally with digital signature and QR code. We're getting a lot of these matters. There's no way of verification whether this is authentic or not.
So they have authenticated. Make sure F page 89.
ಯಾರ್ ಮುಂದೆನೋ ಕೊಟ್ರೆ, if this is given before us, we'll think it is authentic. Yes.
Page 89, my lord, see, if this is one among multiple endorsements issued by BBM. Clearly says, my lord, that the Khata has never changed. It is in my name. My lord, find the column on the right hand side. It says, South Korea, Mahiti, and the Syrian artillery, and the machines, and seven numbers of the site of the day. अंदर ये वाला रहेंगे इसकी की करेंगे खाते खाते रहेंगे खाते खाते कंड बनते रहेंगे अब पूरा एक्चुअली के ಯಾವುದೇ खाते वीडियो में नहीं पड़ी और किलो वैसे कंफर्म दैट वी कंटिन्यू टू फाइंड इट तो सूप प्लॉट हैज कंपोजिट ये सूप को रिजेक्टेड प्लॉट और नाइस सूप हैज बीन डिक्टेड बट नॉट फाइंड कंप्लीटली thinking 20 प्लॉट हैज remained in the market but clearly not an act of perjury.
So what is your allegation? Your allegation is the private litigant has fabricated it, or this is a false certificate issued by the BBM?
No, yes, private litigant was fabricated. That is the reason we are addressed to complaints to the BBM. And then request for them to take steps in investigating. That has not been done.
You are also at liberty to take steps.
That's what is happening. The suit came to me. Connected. The suit was specific forms filed by these private business. That is not the question that I gave to be. But in the interaction, when the proceedings were still pending, since they had the audacity to mark such documents in evidence, but I got it, I may have got the notice of the honorable judge. But parallelly, we request the BPM to conduct an investigation and such to inquire as to whether the authenticity of it. So that it would only complement not anything.
They've already issued an endorsement saying that it's not,
Absolutely.
there's no Kata transfer. What else do you want them to do?
This needs to be confirmed and since it they will have a right not to initiate proceedings against these perpetrators.
Yes. They filed an appeal now.
Yeah, right.
You serve it on the council for them who appears in that. If Pawan Kumar accepts notice for respond number 1 and 2, issue notice to respond number 3 to 5, emergent notice returnable by 12th December. Counsel for the petitioner is also permitted to serve the counsels who appear for respond number 3 to 5 in the regular appeal or RFN, regular first appeal, which is pending consideration before this court. Pawan Kumar is directed to obtain instruction, make a submission. The documents of BBMP will also be required for verification. That is only insofar as your officers who can take penal actions. But for the citizen, you issue a plan sanction, for example. Can the citizen who has received the plan sanction upload it onto DigiLocker and you verify it, so that if anybody comes from your authority, they can just show it and the veracity can be ascertained. It could be a birth certificate, it could be a death certificate, it could be a Khata certificate, it could be taxpayer receipt. Because these documents are used for various other purposes. If you go and apply for something, they say give us a taxpayer receipt, give a Khata receipt. So these documents could be digitized and put into DigiLocker. It's worth considering. This kind of veracity, if it is saying that it is genuine, and from that QR code, it could be ascertained whether it is genuine or not. The 6 months, 9 months time which has been taken will firstly be avoided, or rather, before that, people may not even fabricate, because they'll know that they'll be caught. People are fabricating, make it more difficult. Manual, handwritten, in rubber seal, anybody can do. Well, how is your construction? How is your construction? Sure. Later, don't come back saying. If Pawan Kumar accepts notice for respond number 1, 2, 3, issue notice for respond number 4, returnable by, emergent notice returnable by 18th December. Respond number 2 and 3 are directed cause inspection of the property of the petitioner site number. verify and give us this one. Otherwise, like in another matter, some other property was inspected. You have not said anything in your petition. The property of the petitioner in blank, as also property of respondent number 4 in blank, so on so. Give that details. Inspection to be carried out, commencing from 10:30 a.m. on 27th November 2023. Report to be submitted by 7th December after service of a copy thereof on the counsel for the petitioner. Released on 18th. In the event of it being found that the respondent number 4 is putting up construction without a sanction plan, and or that the construction is being put up in violation of the sanction plan, respondent number 2 and 3 to ensure that there is no further construction put up, if necessary, by seeking police help. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order, end of day Monday, failing which the interim order will stand automatically vacated. What is this?
Where I been directed to pay 3% interest for release of third phase price. Pursuant to the notification issued by the government. Yes, page 43. This notification would pertain to
Page number?
for page 43, what is the notification? Demand notice is annexure G was page 46.
Yes, what is the notification?
Because the notification is for the layouts where plans have been approved and the layout is not found within a period of 1 year. Because there for release of sites, there was one of the authorities and the government has directed to collect 3% of interest. Not release the site. In respect of my site.
Yes.
In respect of my layout, I have applied for release of the third phase. The first and second phase have been released. But only the final phase is for production of the certificate from the authority. I produced it. But the authority insisting on this notification.
This notification virtually says that you have to finish the layout, entire layout, within 1 year.
1 year.
So you cannot, by saying I have different phases, I'll have phase 1 to 10.
They will fix 3 phases to release the site.
Have they fixed 3 phases
Yes,
here? Where is that?
First order is not available, but the phase
3 phases, first alle ಮಾಡಿದ್ದಾರೆ ಅಂತ.
phase will be annexure D.
You have to show us the 3 phases they have approved.
Yes, sir. First phase annexure D.
This was in 2015.
Yes, sir.
This notification has come about in 2018.
18.
So your plan sanction is prior to 2018. Then you can't retrospectively apply it. You cannot know about this notification which will come in future. Can you make him bound by something which he did not know at that time? Can after issuing this claim by issuing a notice, 18 notification put mele, you should issue him a notice that now you completed within 1 year. And if you don't complete, I'll levy a 3%. Put him on notice, Alva. That is not done, cannot happen. But CGP accept notice for respondent number 1. Yogesh Nayak accept notice for respondent number 2 and 3. Counsel for the petition to serve 2 sets of the petition along with annexure and said counsel. The operation of the demand notice dated 19/6/2023 by respondent number 3 at annexure G. It stayed till the next date of hearing, considering that the said demand notice is based on a notification issued in the year 2018 when the layout plan sanction in favor of the petitioner was prior to 2015.
But now they have to delete.
Serve it on Yogesh Naik, we'll dispose the matter.
Yes,
Release on 11.
also.
Yes.
Maybe Kata is the name of the petitioner's property. Petitioner's property. Doesn't say a complete respondent.
You are a party to those proceedings. You're respond number 4.
No, was a party.
B.T. Shashikala is a party in Annexure A.
Yes, no. Police party, but Krishnappa is not party. But no notice is ordered and no notice is served on the.
What is the claim of Shashikala and what is the claim of
Shetty sold the property to Shashikala and Krishnappa, petition number 2 by law. But the sale dated 27/9/2021. Transferred in the name of the petitioner.
where the sale deed?
In Bengal.
First petitioner was respond number 4 in proceeding.
This shows a party, no notice.
Ordered.
Hardship notice mail, when you see pay number 16 mail, 16.
Yes.
This is the order sheet maintained by the third respondent. The proceedings were initiated on 24/5/2022 mail. Order sheet opened on 2/12/2020, reserved any case number and kindly see but on 2/12. ಪೀಠಾಧಿಕಾರಿಗಳು ಅನ್ಯ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಪ್ರಕರಣವನ್ನು ಮುಂದುವರೆಸಿದೆ 600 ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಮೇಲ್ಮನವಿದಾರರು ಪರ ವಕೀಲರು ಹಾಜರು, ಎದುರುದಾರರ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಹಾಜರಿರುತ್ತಾರೆ. ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲು ಸೂಚಿಸಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು 13/1/23. ನೆಕ್ಸ್ಟ್ ಮೈಲ 13 ಪ್ರಕರಣ ಕರೆಸಲಾಯಿತು. ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರಿರುತ್ತಾರೆ. ಎದುರುದಾರರಾದ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಸಿವಿಲ್ ಆದೇಶದ ಪ್ರಕಾರ ಖಾತೆ ಮಾಡಲು ಕುರಿತು ಅದರಂತೆ ಕ್ರಮ ವಹಿಸಲು ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗೆ ಸೂಚಿಸಿದೆ. ವಿಚಾರಣೆಯನ್ನು 3/2ಕ್ಕೆ ಮುಂದೂಡಲಾಗಿದೆ. 3/2 ಸ್ವಾಮಿ ಮತ್ತು ಅನ್ಯ ಕಾರ್ಯ even 3/2/24 and 10/3 73/23 ಪ್ರಕರಣಗಳಾಯಿತು. ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರಿದ್ದು ಇದೇ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಎದುರುದಾರರು ದಾಖಲಿಸಿದ ಸಿವಿಲ್ ದಾಳಿಯನ್ನು 3/2022 ವಜಾಗೊಳಿಸಿದ್ದು ಇದೇ ಪ್ರಕಾರ ಸಮಯದಲ್ಲಿ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಕ್ರಮ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಲು ಮನವಿ ಮಾಡಿರುತ್ತಾರೆ. ಮುಂದಿನ ಆದೇಶದ ಮೇರೆಗೆ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಲು ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗೆ ಸೂಚಿಸಿ ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಲು ನಿರ್ದೇಶನ ನೀಡಿ ವಿಚಾರಣೆಯನ್ನು 14/4/2023 ಮುಂದುವರೆಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಮೇಲ 14 ಚುನಾವಣೆ ನೀತಿ ಸಂಹಿತೆ ಕಾರ್ಯದಲ್ಲಿ ನಿರತರಾಗಿರುವುದನ್ನು 9/6/2020. The included order passed on 24/7/2020. No notice is served on the respondents.
And AGA HCGP accepts notice for respond number 1. Malur. DJ Somyaji is directed to accept notice for respond number 2, 3, 4. Issue notice to respond number 5 returnable by 8th January. The operation of the order dated 24/7/2023 passed by respond number 2 at Annexure A. He stayed till the next date of hearing since apparently no notice had been issued to the petitioners before passing of the said order. Process fee and copies to be furnished by end of day 20th, failing which the interim order will stand automatically. Not well. Devraj or Ilva? Devraj. Who are you representing? Respondent number 6, counsel is not well. Pleading idea. What is this? You have filed it or Mr. Prakash? Who has filed this impleading application? Team 9.
Taking the supporting documents with number 5.7 was read before. That's stated in detail.
Who is this impleading application? Who has filed IA 1 of 16? You have filed it. And who are you? A 1 of? When was it filed? When was IA 1 of 6? 1 of 16. Not pending it. You've been brought on record. IA 1 of 16 ಏನಾಗಿದೆ? Is it pending or is it allowed? Prakash? ಮತ್ತೆ ಇನ್ನ impleading application ಅಂತ ಯಾಕೆ? So you've been brought on record as respondent number 9. IA 1 of 16 has already been allowed, and the impleading applicant has been brought on record as respondent number 9. As the registry is correct the appearance of Shri MP Srikanth as advocate for respondent number 9. Yes. Synopsis has to be filed by you, madam. Yes, you are saying.
Yes, we have stated the details of the property, how to
When did you file that?
Yesterday.
Office out?
And we have been instructing the filing, area and certainly copying that because we are preparing the report much prior.
ಯಾರು ಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತ? Our branch will not go and serve on anybody. What branch, how will they go? We are understaffed by 30%. Your office has to serve. Your office, AG's office has to serve. In ನಿಮ್ಮ ಆಫೀಸ್ ಅಲ್ಲ, ಅವರು ನಿಮ್ಮ ಆಫೀಸ್ ಅವರೇ ಮಾಡಿಲ್ಲ, ನಾವೇನು? We don't have any administrative jurisdiction there, so. ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡೋಣ. The problem that happens is if in all courts it will be the same problem. All GAs will be the same problem. But the problem is once it is given now, they will have to look at it, get adjourned unnecessary. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? How many clerks do you have in AG? How many clerks do you have? It may not be proper for us to directly. It may not be proper. We can only tell the Advocate General once he appears that this issue is there. We can tell the Advocate, but not direct. How many clerks do you have?
Section. And saying that there is nobody to serve.
And how many do you have? And first other way.
Yeah.
Now this can all be served by email also.
Yeah.
That we are moving. See, the problem why we are not able to move to paperless is because of this. If you scan all these things and keep it with yourself also, and that can be circulated, it will become part of the record. ನೀವು ಪೇಪರ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ ಇದು ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಬೇಕು ಅವ್ರಿಗಿಲ್ಲ everybody has to be on the same platform. So whatever you file the petitions you are filing e-file ಮಾಡ್ತಾ ಇದ್ದೀರಾ, objections you are filing e-filing, these reports, everything also, if it is e-filed, they can be, that direction we can give. Learned SCGP has filed an affidavit of the Tahsildar Mandya district enclosing various documents. Copy thereof has been served today to the counsel for the petitioner and the other respondents in court. The counsel for the petitioner and the other respondents seek for and are granted 2 weeks' time to go through the same and make their submissions. In several matters, the affidavits, inspection reports, survey reports, etc., are filed by the government advocate, additional government advocate, or the SCGP in hard copy in court when the court proceedings are taken up. The same not time being served on the counsel for on the other counsels appearing in the matter, which would then entail an adjournment of the matter on account of the said counsels requesting for an adjournment to go through the said documents. Since there is already a direction issued to the state government as also governmental authorities to e-file the statement of objections, it would also be necessary to issue a further direction directing the government advocates, additional government advocates, and the HCGPs to file all affidavits, applications, survey reports, inspection reports, etc., filed subsequent to the statement, so it's filed prior or subsequent to the statement of objections, by using the e-filing mechanism. So the same could also be served on the counsels appearing. The same could also be e-served to the counsels appearing in the matter, avoiding such unnecessary adjournments. That SCGP is directed to bring the above direction to the notice of the Learned Advocate General for doing the needful. And direct clerks. Relist on 29th. 29th. 29th ಆಗಲ್ಲ ಫಸ್ಟ್ ಆಗ್ಬೋದು, ಫಸ್ಟ್ ಸೆಕೆಂಡು ಆಗಲ್ಲ, ಫೋರ್ತ್ at the request of counsel for the petitioner, relist inquiry report ಏನೋ ಇದೆ ಅದರಲ್ಲಿ. This is all those katas which had been e-kata which had been issued. Request of counsel for the petitioner, relist on next week. 22nd. ಅವ್ರು ಕೇಳಿದ್ರೆ ಆಗ್ತದೆ ನೀವು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ನೀವು ಬರ್ಕೊಡೋದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಗೆಲ್ಲ. when do you want?
Week starting from 4.
Week start. At the request of Sri V.V. Gunjal and counsel for the petitioner, released on 6th ಅದು ಇದೆಲ್ಲ.
Some difficulty.
ನೀವು ಕೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಯಾಕೆ ಕೇಳು? He understands. Yes. For challenging a letter issued by respond number 3 requesting the respond number 1 to acquire your land.
Yes. No, the responding number 3 is our land will be acquired.
Where is the letter page?
Because it's addition A. 12 numbers. That is the second notice. Addition B is at page 14. The first notice.
Where is the relevant portion? Please read the relevant portion.
Page 13.
Actually, at page 13, yes. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? ಆದ್ದರಿಂದ
ಪರಿಷ್ಕೃತ ವಿನ್ಯಾಸ ನಕ್ಷೆಗೆ ಹಾಗೂ ಕಟ್ಟಡ ಪರವಾನಗಿಗೆ ಮುನ್ನಡೆ ನೀಡಿದಲ್ಲಿ ಸದರಿ ದಾಖಲಾತಿಗಳನ್ನು ಈ ಪತ್ರ ತಲುಪಿದ 2 ದಿನಗಳ ಒಳಗಾಗಿ ನಗರಸಭೆ ರಚನೆಗೆ ಹಾಜರುಪಡಿಸುತ್ತಾರೆ. ರಸ್ತೆ ಜಾಗವನ್ನು ಸೇರಿಸಿ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ 2883/283 ರಲ್ಲಿ ಹಕ್ಕು ದಾಖಲಾತಿಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ವಿಸ್ತೀರ್ಣ 9305 ಚದರ ಮೀಟರ್ ವಾಣಿಜ್ಯ ಉದ್ಯಾನವನ ವಾಹನ ನಿಲುಗಡೆ ಬರೆಯುವಂತೆ ನಿಗದಿಪಡಿಸಿರುವ ನಿವೇಶನಕ್ಕೆ ಅಳತೆಯನ್ನು ನಗರಸಭೆ ದಾಖಲಾತಿಯಲ್ಲಿ ನಿಮ್ಮ ರಸೀದಿಗೆ ನಮೂದಿಸಲಾಗುವುದು ಹಾಗೂ ರಸ್ತೆ ಜಾಗವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಕಟ್ಟಡ ನಿರ್ಮಿಸುವುದನ್ನು
the extent of land owned by you?
That is 2 acres 15 guntas minutes. Thereafter, conversion is obtained minutes. That is at direction H.
2 acres 15 guntas.
Yes, minutes. That is after obtaining conversion minutes.
It is 1,03,455 feet.
Yes, the conversion is obtained to 9,611 square feet.
9,611 square meters.
Yes.
Yes.
Conversion is obtained minutes. Thereafter, minutes constructed and running a resort in the premises.
Yes.
But the project approval order is also being obtained minutes.
Page.
Page direction in
9,611.
Yes, sir.
Where does it say that?
Approval for construction works. The annexure H at page number 70 is the conversion order results.
Because 15 months, yes.
Therefore, because in the year 2017, the respondent number 3 comes near the property and orally states that 1.5 meter of land in front portion will be acquired for the purpose of widening of road members. Thereafter, I take the representation to us. It's like annexure L, stating that you know the exact extent of land which will be acquired. Annexure N at it 82 members. Representation, the respondent number 3 emails a petition from the members and for discussion fixing compensation to land members. The extent of 1.5 meter, which is 0.04 members. That is at annexure P members, page 83.
Yes.
Thereafter, when I did not get a reply, I again made the representation members, which is at annexure Q. Again, a meeting will be conveyed and I will receive an invitation again with us for fixing of compensation.
26/9.
Respondent number 3, we issued this annexure impugned letter members, which is an annexure.
Till now, the compensation has not been fixed, agreed upon.
No matters. That is not being fixed without initiating execution proceedings and without awarding any compensation.
Yes, Mr. Naveen?
The private property belonging to the petition will be
Hmm. 15 months. 11 square meters. Yes. Where's the plan sanction? The plan has been produced? Yes. Yes. Yes, please go ahead. No, this road is outside the property for widening up of the existing CDP road. Yes. Yes. Page 14. Yes.
has done is located Kasa in respect of 9611 square meters of.
He is the owner of it, owner of the property. If you want to use it for the road, which is being demarcated in terms of the CDP, you do so by excising powers under section 69. Excess yella pabatto. 2 acres, 15 guntas is owned by them, which translates to 9,611 square meters. That is what they have got the kata for. They have not built on 306 square meters because there's a proposal to widen the road. That is why the planning authority has not sanctioned the building on that area proposed to be widened. So if you want that property, whether the planning authority or you want that property for widening of the road, section 69 is what you have to resort to. Without that, you cannot say, I'll deny the kata, I'll reduce the kata, I'll do this, I'll do that. Ella threaten madakagalla. It is not contrary. On the 306?
These are notice.
Where do you say that he has constructed on 306? Yes. Hmm. Construction ಇದೆ ಅಂತ ಹೇಳಿಲ್ಲ ನೀವು. This is acquisition by. You can't do this. Fair. There are enough and more judgments of this court on this. I've already dealt with all of them. You know, I have no jurisdiction to issue that notice. We are seeing all the authorities issuing the notice, like this notice, forcing people to execute relinquishment deeds without following law. Again, Papa, it is coming from a government authority and the citizens will get scared and they'll do what is told. Unless they go to a lawyer. How many people can afford to go to a lawyer? We'll deal with that. We'll deal with that. So, Krishna is before this court, seeking for the following views. Krishna seems to be the absolute owner in possession of property bearing survey number 440, measuring 2 acres, 15 guntas, situated at Chamrajnagara Kasba village, Chamrajnagara district. The petitioner had approached the Department of Tourism for setting up a resort, which came to be approved by the Department of, which project came to be approved by the Department of Tourism on 22/11/2010. Thereafter, the petitioner wanting to set up a resort in the said land had obtained conversion the land from agriculture to non-agriculture purposes on 26/11/2007. As also a plan for construction of the building in the said land. Project being a resort, the petitioner had also approached the Department of Tourism for necessary approval, which also came to be granted on 22/11/2010. Subsequently, the project had been set up in the year 2017. Respondent number 3 informed the petitioner that 1.5 meter of land would be required for widening of the road situated in front of the property, abutting the Krishnarajpura road, in pursuance of which various discussions were held between the petitioner and respondent number 3 as regards the compensation liable to be paid for the said land. However, without fixing the compensation, the respondent number 3 issued Annexure B notice indicating that the land which had been earmarked for widening of the Krishnarajpura road, measuring an extent of 306 square meter, would have to be deducted from the kata which had been issued to the petitioner for an extent of 9611 square meters, which was followed up with a second notice on 7/10/2020, calling upon the petitioner to come forward and relinquish the extent of 306 square meters, so the kata could be issued for balance 9305 square meters. It is agreed by saying that the petitioner is before this court seeking for the opposite relief. Mr. Also, learned counsel for the petitioner would submit that though the land might have been earmarked for widening of an existing road in the CDP, the procedure under Section 69 of the Karnataka Town and Country Planning Act 1961 has not been resorted to, and without acquiring the same in terms of subsection 1 of Section 69 under the Right to Fair Compensation So-and-so Act 2013, there cannot be a demand made by respondent number 3 for relinquishment of the area earmarked for widening of the road. The petitioner continues to be the owner of the said land, and as such, the kata which has been issued for the entire extent measuring 9611 square meters, being proper and correct, cannot now be reduced on is a proposed widening of the road, which in fact has not occurred till date. On these grounds, she submits that the prayers which have been sought for are required to be granted. The Nagarajappa A. Learned Counsel appearing for respondent number 3 would submit that though initially there was negotiation held between respondent number 3 and the petitioner for arriving at a compensation payable, respondent number 3 having subsequently come to know about the plan sanction which had been issued, which clearly denoted 306 square meters for road expansion. The planning authority not having granted a plan sanction in respect of the said 306 square meters, the petitioner cannot claim a kata in respect of 9611 square meters, but ought to have restricted it to 9305 square meters. And it is in this background that the notice dated 28/9/2020 and 7/10/2020 have been issued. The submission is that the plan sanction has been granted only in respect of 9305 square meters. The petitioner would be entitled to kata of only 9305 square meters. And the petitioner, not having obtained a plan sanction in respect of 306 square meters, no kata could be claimed by the petitioner. This plan sanction had been suppressed by the petitioner at the time when the kata was issued. And as such, on the respondent number 3 coming to know of such suppression, has issued the aforesaid notices. Ashtala. On the above background, he submits that the above petition is required to be dismissed. heard so and so produce papers. The short question that would arise for consideration in the present matter is whether merely on account of the planning authority earmarking an extent of land for widening of an existing road, or in this case specifically stated as road expansion, the municipal corporation can contend that the area denoted or reserved for widening of the road is not the property of the landowner and thereby reduce the extent of land mentioned in the Kata already issued. It is not in dispute that the petitioner is the owner of the land in survey number 440/2, so also measuring 2 acres 15 guntas, which had been converted for non-agriculture purposes. They said 2 acres 15 guntas translate to 9611 square meters, which is also not in dispute. The petitioner, having obtained a plan sanction for construction of a resort, is also not in dispute. The only contention urged by Sri A. Nagarajappa is that the area demarcated, area shown for road expansion of 306 square meters would not fall in the entitlement of Kata in respect of the petitioner. A perusal of the plan produced by respondent number 3 indicates the land utilization as under: 1. Commercial 7805 square meters. 2. Park 1000 square meters. 3. Parking 500 square meters. 4. Road expansion 306 square meters. Total 9611 square meters. Thus, the plan itself would indicate that the utilization is in respect of 9611 square meters and not in respect of 9305 square meters as now sought to be contended. The plan does not distinguish the land of the petitioner in terms of ownership or otherwise, but only sanctions a construction, only sanctions the plan in respect of the usage thereof as shown therein. In the present case, the existing 18-meter wide road, Karinanjapura Road, is proposed to be widened in the CDP. Since the same is demarcated as such in terms of Section 13 of the Town and Country Planning Act 1961. Whenever there is any demarcation made for a particular purpose under Section 13 of the KTCP Act, it is only the procedure prescribed under Section 69 which would have, of the KTCP Act, which would have to be resorted to. In terms whereof it is required that acquisition of such land belonging to a private person to be made use of for the particular purpose denoted in the CDP be made under the Right to Fair Compensation so and so Act 2013. The KTCP Act does not prescribe or make known any other mode to the municipal corporation or the planning authority to exercise ownership over the land of a private person without such acquisition. Thus, merely because a portion of the land of the petitioner has been shown to be used for road expansion would not denude the petitioner of title over the said property, nor does it confer, let alone confer, title on the corporation, city municipal council, as regard the said land, without acquiring the same under the right to fair compensation so and so. Thus, I answer the point raised by holding that there is no suppression made by the petitioner insofar as the ownership of the land is concerned, as regards which the petitioner is entitled for the kata. The third respondent cannot, on the ground that a portion of the area is marked for widening of the road in the CDP, claim any ownership thereof or deny ownership to the petitioner. In that view of the matter, I pass the following order. Petition is allowed. The impugned notices period 7/10/2020 and at Annexure B and 28/9/2020 at Annexure B and 7/10/2020 at Annexure A, being without jurisdiction, are hereby quashed. In the event liberty is however reserved to respond number 3 to acquire the land if it so desires in terms of subsection 1 of section 69 of the KBCP Act. Needless to say, if any construction is made by the petitioner on the said 306 square meters of land demarcated for road expansion, the petitioner would not be entitled for any compensation as regards such construction upon acquisition by respond number 3. Further, needless to say, that respond number 3 shall not take any action against the said construction until acquisition is complete. Now, don't use this to go and demolish. First, you acquire. One. Acquire ಮಾಡೋವರೆಗೂ ಏನಿಲ್ಲ ಇದ್ರೇನು ಏನು ಪರವಾಗಿಲ್ಲ. They won't be entitled for compensation. Yes. We take it up at 2:30. Go by the list and we'll take it up there. Mohan Kumar, Mr. Natraj, yes. Yes, Mr. Rajgopal. Yes. E21. You know the construction put up?
That construction is after 1976. The board said, in 2012, my lord, it is got to be altered, and it is in the roof. Then we not introduce or initiated under section 321. And the prayer is classified by stating that it is legal amongst the instruction or an alteration. It is only a debate. It is protected under section 320, therefore 321 notice. The final order was pointing that we have not filed any objection, despite objection is on record.
Mohan Kumar, even otherwise would it come under Akrama Sakrama? 75 construct.
So they were talking between the correct.
Is the construction prior to 2013 or post 2013?
As per 1997, there was a 6 cent of a building. In 2013, it now 10 cents of the building has been, as per their own architect.
Adu encroachment, adu bere. That is between them to sort out.
Alteration melody, or an alteration melody, the character has not been extended. Here, my lord, this is the case where it has been extended, the building has been extended.
When?
2013.
2012.
See, the problem is that if it is prior to 2013 and you only have amended Akrama Sakrama and got in this one. If the Supreme Court upholds it and we redirect demolition, we can't turn the clock back. If Supreme Court says, strikes down Akrama Sakrama, then we can demolish. Demolish ಮಾಡಿಬಿಟ್ರೆ ಆಮೇಲೆ uphold ಆದರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. That is the situation that we are put in now. If it is post 2013 construction, then we are taking action.
That's what I'm saying. They themselves are doing a lot and we're taking worship and attention. The feelings of the past.
Yes.
I come to. I pay number 68, not when the appeal appellant, the petitioner while an appeal before the appellant authority.
68.
68, you know, appeal number 274, you know. Around number 6, you know. Meantime, the appellant undertook the renovation of the month of April 2005, certain last favor to the old structures standing between the loss of repair of the same as there was the damage to the roofing and asbestos sheet used in the apart appellant undertook certain alteration and modification for the purpose of basket. In turn, one Mr. Prasad wants to also in no way related to civil property, but in contending that the use of the same is showing personal interest to gravitation property.
In 2012, provisional order was issued on 9/1/2013. So prior to the Akrama Sakrama.
They felt happy where the order has been passed, and take the logic and attention to.
That's right. We are not on the merits right now. Is this prior to the Akrama Sakrama scheme coming into force or after? Is it covered under Akrama Sakrama scheme is what we are asking Mr. Mohan Kumar. If it is covered, ಅವರು ಹೇಳ್ತಾರ ನೀವು ಹೇಳ್ತಾರ provisional order is 9/1/2013.
Prior to 2000.
The cutoff date is fixed by Akrama Sakrama as date in. Then it will get covered. You'll have to wait for the Supreme Court judgment and then pass orders. Demolish ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅಲ್ಲಿ uphold ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು? We can't get into those things.
Of course, that's appeal is filed by them. The appeal, the observation made by the appellate authority is not paid. They contain that no, we did not construct, we only renovated. Subsequently, this all passes an order directing the appeal authority conduct an inquiry and report to police. They conducted an inquiry, they evaluated that there is new construction made by them. From time to time, they have made a new construction.
Whatever it is prior to the cutoff date.
That's what cutoff date is.
So if cutoff date is there, they can always ask for regularization.
Who has to seek regularization will not be the person who is in permissive position cannot seek because the Kata stands in by safety stands in respondents he is the owner of the property. The person who is in permissive position.
That will be decided in that suit, Mr.
Person who is in permissive position. He entitled to put the construction on basis of without sanctions.
We can't get into all those things. We are sitting in writ petition. We are not sitting in RFA jurisdiction. If RFA jurisdiction is then we can consider. Our roster is WP, LB.
Consideration, point for consideration is this. Whether the construction is made pursuant to the plan or not, no plan is obtained by them. Now when they get update and they can save the building. But update then we can make submission.
Cutoff date is 2014. The problem. We'll just adjourn it. We're reserving liberty to you, both of you, to move the matter after Supreme Court judgment. That's what we have done in 2 other matters. If the construction has happened after 2013, with or without plan sanction, we'll take it up. But if the construction is prior and provisional order is 2012, January 2013. So, when the 2012 well construction, 13-1. In the present matter, the construction, the alleged illegal construction put up by the petitioner is in the year 2012, which probably would be covered by the Akrama Sakrama scheme propounded by the BBMP, which is pending consideration by the Honorable Apex Court. In the event of the Honorable Apex Court upholding the Akrama Sakrama scheme, and this court directing demolition, the petitioner cannot be put back in the position that he was. However, considering that the petitioner has been in possession of the property and the matter being pending for nearly 7 years, the interest of both the parties would not get adversely affected if the judgment of the Honorable Apex Court is abated. Preserving liberty to all the counsels to move this court on the judgment being rendered, the petition is adjourned sine die. Sine die. SINEDI. Yes.
Number 8.
Yes.
Schedule A property. And actually owner of this. Part number 1. Without issuing any notice, without any acquisition. Acquire schedule B property.
For what purpose?
Any purpose. File the suit number. Against the respondent number 1. In the year 2011, which is a page number 32 months.
Yes.
Page number 40 minutes. Judgment. Page number 14. If the dependent. If the dependent intends to construct a claim, liberty to construct as per the procedure of law, but the defendant has no right to ensure the form of property of the plaintiff without making any acquisition order. As per the exhibit, defendant tries to ensure the plaintiff property without conducting any legal process. In spite of this order.
Yes, madam, have you used the property? Yes, if they get a plan sanction, layout plan sanction. Where do you say that? 12? Yes. Can you impose such condition? What law have you imposed this condition? We understand you impose a condition, but what gives you authority to say that I'll convert your property, but you give me 30 feet of road? Conversion is not a disguised acquisition. Then you have no power to issue it. You will put 100 conditions. People will come to you for conversion, they'll presume that you will act bona fide. And you act mala fide by taking away their land, by issuing conversion, while issuing conversion order. What is the power to say you will give me 30 feet of road? When these conditions for conversion to be different from the standard conversion orders. The conversion orders are saying where you, if you want to use the property, you have to apply for and obtain sanctions from the concerned authority. There, for the layout plan sanction, 10%, 15%, those are there which have to be given. But here, without anything, only give me 30 feet road and laying it. After arguing for some time, Learned Counsel for respond number 1. 6 point is granted a week's time to obtain instruction, make a submission as to on what basis condition number, on what legal basis condition number 15 and 21 have been imposed in the conversion order at Annexure A. Which order dated 14/10/93 at Annexure A. Relist on 1st December. Yes. Yes. Drainage has been constructed by them. Road margin, they have not constructed anything. They have not
constructed only.
Their grievance is
State land.
even if road margin is left, it is only to give that margin. Why? Is for a future expansion of the road. And acquire construction adakku compensation should not be there unnecessarily. That is why the road margin is there. But once it gets widened, road margin goes. So if they have to acquire it and then do whatever you want. Private land. SDN Prasad has entered appearance for the petitioner. Delete the name of Sri Jairaj DS as that appearing for the petitioner. Council seeks for and is why? Inconvenience. Seeks for. Yes, Mr. Brajesh. Ready. Council for the petitioner seeks for a short accommodation to address argument. That council for respond number 2 seeks for on 18 matter. 6 point is granted 2 weeks time finally to file a statement of objection. Objections if they need to be filed on or before 1st December 2023, failing which will be taken as not filed. Relist on 8th December. Ready? Pass over. Ade. Brajesh Patil. Ministry is correct the appearance of the council for respond number 4 as Brajesh Patil. That council for the petition. All pleadings are complete. So when will you file your objections? Tomorrow. Very good. Mr. Brajesh. You'll file objections tomorrow and you copy serve. You'll file objections, serve it on you. So 19 matter in a copy.
interaction between the parties. And
We are not concerned. We are concerned with this only. Mr. Unni Krishnan. Where is Mr. Unni Krishnan? Has he filed objections? Has he filed objections? Correct. Question clearly. What relevance is pleaded or not? That counsel for the petitioner seeks for a short accommodation. That counsel for respondent number 3 submits that you will be filing a statement of objection in 2 days' time. Copy. Okay. Counsel for the petitioner undertakes to furnish a copy of the petition along with annexure on counsel for respondent number 4, who seeks by the end of day today, who seeks for and is granted 3 weeks' time to file a statement of objection. Objections, if any, by 8th December. What about respondent number 5 is filed? Similarly, 3 weeks' time is granted to respondent number 5 to file a statement of objection. If the same is not filed by 8th, it will be taken as not filed. It is done. 14.
That's kind permission.
Mr. Umashankar.
But next matter, my lord, serial number 48. I appear for KVT. Return agidiyante. First time it is listed, my lord. After it is not listed for preliminary hearing.
2019 the first time.
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ.
ಏನ್ ಮಾಡಿದೀರಾ?
It was in the office objection, my lord. I appear for KVT. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಬೇಕು.
ಕಾಪಿ ಸರ್ವ್ ಆಗ್ಬೇಕಾ?
ಹೌದು ಆಗ್ಬೇಕು, ಇನ್ನ ಆಗ್ಲಿಲ್ಲ.
ಪೆಟಿಷನ್ ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ.
48 ಒಂದ್ ನಿಮಿಷ. 48 ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು 2019.
It was listed on 13/12/2021, my lord. To comply office objections.
Umashankar, can we take up this matter? Can we take up this matter?
Please, my lord.
ಇನ್ನೂ ಒಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇಲ್ವಾ ಇದು?
ಏನಿಲ್ಲ. ಇದರಲ್ಲಿ
Umashankar, who has filed KVT, accepts notice for respondent number 1 and 2. Counsel for the petitioner is direct furnished 2 sets of the petition, a set of the a copy of the petition along with annexures on Shri Umashankar, which counsel for the petitioner undertakes to do so by end of day 18th. Counsel for respondent number 1 and 2 seeks for and is granted 3 weeks' time thereafter to file a statement of objections. Objections, if any, by 15th December, released on 19th December.
Please, my lord.
51 ಏನ್ ಮಾಡ್ಬೇಕು? 51 ಇದ್ರಲ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆಯಾ? ಸೇಮ್ ಮ್ಯಾಟರ್ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾ? 48 and 51 same parties. 48 and 51 connect. Shri M. Umashankar seeks for and is granted 3. Registry is direct correct the appearance of the counsel for respondent as Umashankar MN. Umashankar MN. Who seeks for and is granted 3 weeks' time to file a statement of objection. Same. Yes. T6. You want to? ಏನಕ್ಕೆ Mr. Vivekananda? Counsel for Shri T.P. Vivekananda, counsel for respondent seeks for and is granted 2 weeks' time to ascertain if notices had been served on the petitioners before the impugned order was passed. Released on 11th December. Interim orders earlier granted as extended 2 weeks. Have you informed the respondent? ಏನಕ್ಕೆ ಟೈಮು? 76. Accepting the reasons stated in support of IA 1 of 2023, the production of the certified copy of annexure also is dispensed with, subject to any serious objection being raised by the respondent. Counsel for the petition seeks for and is granted 2 weeks' time to get ready and address his arguments. Released on 11th December. Interim order earlier granted is extended. Have you informed the respondent? Objections ಹಾಕಿದ್ದೀರಾ? Good time ಬೇಕು. Particular learned counsel for the petitioner seeks for 2 weeks time to place certain documents on record. Weeks time to place certain documents on record. The learned counsel for respond number 3 and 6 seeks for 2 weeks time to file a statement of objection. Objection if any by 8, relist on 13.
My kind permission. I'm sorry.
Yes, Mr. Umashankar, one nimsha. Yes, 52. Counsel for respond number 1 and 2 seeks for and is granted 2 weeks time to file a statement of objection. To be filed on or before 15th, relist on 19th. One nimsha. 37. Yes. ನೀವು ಯಾರಿಗೆ? Have you informed the respondent? ಏನಕ್ಕೆ? ನೀವು ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸೌಮ್ಯ. Yes, Naveen, you have filed your objection? That counsel for respond number 3 and 4 seeks for and is granted 2 weeks time statement of objection. Objection is pending by 15. Relist on 18, 19. Interim order earlier granted is extended till next day. ಏನೋ ರಿಪೋರ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು. Counsel for the petitioner submit that he does not press IA 1 of 2023. As such, IA 1 of 2023 stands dismissed. Accepting the reasons stated in support of IA 2 of 2023, the production certified copies of annexures C, D, D1, D2, F, and G is dispensed with, subject to any serious objection raised by the respondents. Counsel for the petitioner has received the inspection report today, confirms receipt of the inspection report today. He seeks for and is granted 2 weeks time to go through the same and address his argument. Relist on 8th December. Interim order earlier granted is extended till next year. 55. ಏನಕ್ಕೆ objection? Counsel for full ಕೂತ್ಕೊಂಡು objection ಮಾಡ್ಬೇಕು ಇನ್ಮೇಲೆ. Counsel for respond number 2 seeks for and is granted 2 weeks time to file a statement of objection. Objection if any by 15th. Relist on 20th. Interim order earlier granted is extended till next week. Yes, Mr. Umashankar.
My lord, you last said granted date on 19/12, my lord. Instead of that 18/12, my lord. Serial number 48, my lord. 48 and 51.
19/12 ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀರಿ ನೀವು?
ಅದೇನು ಡೇಟ್ ನೋಡಿದೆ, ಅದು ಕ್ಲಾಶ್ ಆಗ್ತದೆ.
48 and 51. 51 ನಿಮ್ದೆ ಅಂತ ಹೆಸರು ರಾಂಗ್ ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ಹಾಕಿದ್ದಾರೆ. 18th ಅಥವಾ 20th ಸರ್?
18th.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
61. SN Prashant Chandra has entered appearance for respond number 1 to 5. The registry is direct delete name of Shri V. Srinidhi as that appearing for respond number 1 to 5. He seeks for and is granted a week's time to get ready and address arguments. Relist on 11th December.
Hello, court officer, madam? Hello? Hello? ಮೆಂಟೇನ್ ಮಾಡಿದೆ. ವೆಂಕಟೇಶ್ ಮೆನ್ಷನ್ ಮಾಡಿದೆ. ಅಲ್ಲ, 2 ಮ್ಯಾಟ್ರ್ ಇದೆ ಆಕ್ಚುಲಿ. ಅದು ವಿ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದು ಅವರು 18th ಅಂತ ಹೇಳಿದೆ ಡೇಟು. ಅದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ಬಿಡಿ. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, ನಾನು ಇವಾಗ ಮೆನ್ಷನ್ ಮಾಡಿದೆ. ಮತ್ತೆ 19, 12 ಅಂದ್ಬಿಟ್ರು. 18, 12 ಮಾಡಿ ಅಂತ ಹೇಳ್ದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ಬಿಡಿ ಅಲ್ಲಿ.
ಹಾ ಸರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಅದು.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಸರಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಮೇಡಮ್ ಇದಾರಲ್ಲಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಇದನ್ನ ಇಲ್ಲಿಗೆ ಇಡ್ಬೇಕಂತ ವೈರ್ ಇದೆ. ಇದು ಇಲ್ಲೆಲ್ಲ ಮುಗಿಸಿ ಇಲ್ಲಿಗೆ ಇಡಿ. ಹಾ.
Pawan Kumar, Learned Counsel for respond number 1 and 2. Submit that the draft is placed before the Chief Commissioner for approval. Given a week's time, the same will be placed before, the approved draft will be placed before. Approved the end code. Yeah, approved circular would be placed on the records of this code. Released on 29th December 5th. Counsel for the petitioner has carried out the amendment and filed amended. Carried the amendment, served a copy of the amended cost title on the response. Readings are complete. Released on 11th December.
Like the office objection was produced with enlarged copy of the plan, which is annexure E. Now, here I have to do the annexure A4 size. A4 because in A4 size. Now it's in A3 size, I have produced. Now the office is asking for a plot of size, but it's a Xerox copy of this plan, more than this cannot be zoomed out. That is the
Answer no, can't say right.
Plan number, plan open ಮಾಡಿದ್ವಿ, that is
Page
not-
number.
Next page number 35.
Read anything, Mr. Srinivas? Can't read any of these. What are you relying on this for?
Well, I have returned the plan letter, that's what I wanted to show. Plan number is available in the bottom and that is legible.
An allegation is that you have violated it.
Violated the sanction plan and the challenge the confirmation order. Around that, the assistant executive engineer have no power to issue the.
Are no longer available? Again, 248.3 ಆಗಿದೆಯಾ?
248.3 ಆಗಿದೆ. And
You
because
go on
it was
appeal.
not at all served upon me in 2021. I came to know only on 85/2023 when Tiruvalli Patra came. Till then I was not aware of this at all.
That ground of AE is not available. Division bench has stated. So you'll have to go before the appellate authority.
Subject to result of it, till the disposal of it until
We'll, I mean, not to take any steps until you file the appeal. Go there. Why should this wait? Shri Pawan Kumar accepts notice for respond number 1 to 3. ಆಗಿದೆಯಾ? ಚೈತ್ರವರ್ತಿ ಆಗಿದೆ. The grievance of the petitioner is before this court seeking for the following leaves. Grievance of the petitioner is that the notices under section 248(1) confirm provisional order under section 248(2) and confirmatory order under section 248(3) of the BBMP Act 2020 have been issued by the assistant executive engineer who does not have the power to do so. Even if that may be the case, it is for the petitioner to approach the appellate authority, namely the chief commissioner, in terms of section 253 of the BBMP Act 2020. That view of the matter, I pass the following order. The petition is disposed, reserving liberty to the petitioner to file necessary appeal before the chief commissioner under section 253 of the BBMP Act 2020. If the same is done before, the same is done, the same is filed on or before 8th December, the respondents, until then, the chief commissioner shall consider the same. Until then, respondents are restrained from any manner taking any coercive steps against the petitioner. In the event of no appeal being filed by 8th December, respondents are free to take such action as is available. Certainly.
With regard to ruling of no confidence voted in respect of the law consent.
If it has been filed only by respond number 4, Mr. Patil. Only respond number 4. Yes.
But the first objector was elected on 18/1/2020.
18th
of January 2022.
When was the election?
That is, the first election was, the term started from 2020 to 25.
The election to the panchayat ಯಾವತ್ತು?
Election to the Adhyaksha, post of Adhyaksha.
Election to the panchayat ಯಾವತ್ತು?
27/12/21.
27/11/12/2021.
27th December 2021.
And first Adhyaksha was from?
The first
30th December 2021. 18th January 20.
18th January 2022.
18/01/2022.
Yeah.
Yes.
Then Lord, she resigned from office. After resignation,
Resigned on?
resigned on 22 February 2023.
22 to 20?
22 February, 22nd February 2023.
23. Yes.
Then the petitioner was elected on 7th of March 2023.
Yes.
Now, Lord, the no confidence motion has been moved against the petitioner on 18/10/2023. On that, Lord, the notice has been issued on 4/11/2023.
Yes.
Now, the Supreme Court, Lord, whether this prohibition of not moving no confidence motion, the 15 months. Now, does it apply from the date of my election or from the date of the first election? It's the issue. There is one judgment, Lord, which is against in the context of the previous amendment. That is, the Lordship will take the action. Section 46. Yes, one, the term of office of every Adhyaksha and every Upadhyaksha of Gram Panchayat that same as otherwise provided in this act 30 months from the date of his election or till he ceases to be a member of Gram Panchayat, whichever is earlier. So the term is either 30 months or he ceases to be a member of Gram Panchayat. So therefore, the other provision is 49. Motion of no confidence. Every Adhyaksha or Upadhyaksha of Gram Panchayat can forthwith be deemed to have vacated his office with a resolution expressing want of confidence in him if passed by a majority of not less than 2/3 of the total number of members. Gram Panchayat. Anything specially convened for the purpose in accordance with the procedure that I described. Provided that no such resolution shall be moved unless notice of the resolution is signed by not less than 1/2 of the total number of members. The 10 days notice has been given of the intention to put a resolution. Provided further that no resolution expressing want of confidence against the Adhyaksha or Upadhyaksha shall be moved within the first 15 months from the date of his election. The earlier amendment prior to this was under section 49. The earlier, that is 49 subclause 3, provided that no resolution expressing want of confidence against Adhyaksha will be moved within the first 15 months followed was earlier 30 months. And the total term followed was 5 years.
Yes.
Earlier. Now, in the context of the amendment as it was prior to this 31/3/2020, this court took the view that no doubt on the base of plain language of the date of his election 15 months ago, it appears that 15 months to be done. But in a case where the total term is 5 years, and for 30 months no confidence motion can be moved, that would result in a situation where if one person resigns and thereafter another person is appointed for the total 5 years,
no confidence motion cannot be moved at all. So it leads to an absurdity. So therefore, in that context, the court interpreted the date of his election means the date of the first election. But now by virtue of the amendment, the total term is only 30 months. Now within 30 months, within half, not 15 months, they cannot move. So it is my submission that the law laid down in the earlier judgment is no longer valid.
Due to the amendment.
No longer valid because that reasoning is not valid. Now when the section specifically says 15 months should not be, no conflict should not move, that is expected to give some kind of a fixed tenure to a Adhyaksha. Out of total term is 30 months, 15 months. Now even thereafter also another 2.5 years is always there. So the reasoning which is given in the earlier judgment to say date of election means the date of his first election, that may not hold truthful or is my submission. You have to have a look at that judgment.
Same judgment.
The same judgment, I'm not real it's easy to refer to them.
Yes, please.
Paragraph 7.
Yes, please.
Plain reading of second proviso to section 49(1). The second proviso is no longer there, it is deleted. 49(1) of the Act appears to indicate that there is a bar regards moving of a motion of no confidence within first 30 months from the date of his election. It is to be noted that the term of office as regards Adhyaksha under section 46 of the Act is 5 years. 5 years from the date of his election. Or till he ceases to be a member of the Gram Panchayat, whichever is earlier. It ought to be noticed that earlier the term of office under the unamended section of 46 of the Act was 30 months. Similarly, the prohibition under the second proviso of section 49 of the Act earlier was 1 year. The time of 1 year and 5 years as found in 49 and section 46 of the Act has been altered by way of an amendment. Insofar as the term of office of Adhyaksha or Upadhyaksha is now 5 years. As per the amendment inserted on 34/2015 by Amendment Act 17 of 2015. And almost contemporaneously an amendment of second proviso to section 49 of the Act, which provides for the period of prohibition to move a motion of no confidence, came to be altered to 30 months as per the amendment made on 23/2016 by Amendment Act 44 of 2015. And it becomes clear that the legislature in its wisdom while making an amendment to section 46 as well as 49 of the Act, as by conscious legislative intent altered the period of prohibition as well as the period of office of Adhyaksha or Upadhyaksha as noted by amendment. To accept the contention that the period of 30 months as a prohibition to move the motion of no confidence would commence from the date of the Adhyaksha having been elected, though would appear at first blush to be a correct literal interpretation. Adoption of such an interpretation in the present fact would lead to absurdity, where the prohibition under section 49 of the Act is thought to be made applicable where Adhyaksha is elected for the second time, consequent to resignation of the Adhyaksha elected at the earlier instance. If this interpretation is accepted, then the bar envisaged under second proviso to section 49 is come into play whenever an Adhyaksha is elected. If Adhyaksha resigns or vacancy arises, and an Adhyaksha is elected once again, if the bar under the second proviso is to operate, then no motion of no confidence can be moved during the whole term of 61. Obviously, such an interpretation would lead to absurdity. The correct interpretation, keeping in mind the objective and intent of the statute by adopting an appropriate rule of interpretation, would be to assign the appropriate meaning from the word from the date of his election by taking into account the period as prescribed in the section 46 read with section 51 of that, which would be the term of 30 months is to be calculated on the date of the first election of Adhyaksha. This also becomes clear from the use of the word within 30 months as provided in the section second proviso to section 49 of the Act. This 15 months, 5 years, that is 60 months and 30 months, came to be amended
Act 49 of 2020.
Yes. Nine.
Act 49 of 2020 is the section 46.
9 of 2020 ಅಲ್ಲ?
That is Act number 49 of 2020. Section 46, in section 46. The term, it is 30 months. That is inserted by Act 49 of 2020.
Yes, section.
The 46, subclause 1.
Which amendment section ಯಾವುದು? Section 8 and 10. Yes. 5 years become 30 months.
Section 49 also is amended. Section 49.
Yes.
Second proviso, 15 months. So substituted by 30 months back, 49 of 2020 shall be deemed to have come into force on 31/3/2020. The clause which is prohibition 49 proviso makes it clear that provided further that no resolution expressing want of confidence against the objection shall be moved within the first 15 months of the date of his election. Second proviso makes it clear that from the date of his election. It is not a case where the date of the first election is not concerned. The date is relatable to the objection question.
When was this proviso inserted?
Proviso was inserted in 97 only. Second and third proviso is
97.
inserted in Act 29 of
29 of
49.
29 of 97. ಅಲ್ಲಿ there's no amendment to 46 or 49. At 29 of 98. 29 of 97. No statement of different purpose for this. ಅದಾಗಿ ಅಲ್ಲ, when was this restriction of the period first introduced is 97 ಅಂತಾರೆ. 97 yes, when was it first introduced?
Second and third proviso inserted by Act
Shall
29.
be inserted by section 13 of Act 29 of 47. Again, why it is inserted on any line? There is no statement of objection reasons.
97, page 523.
Yes. 523 ಶುರು ಆಗತ್ತೆ.
ಇದು section 13 of the Amendment Act.
Yes.
575.
Yes. Is there any statement of objection reasons for introducing second and third proviso? Why was it felt necessary to introduce the second and third proviso in the year 1997? Vidya, the ಬಗ್ಗೆ? There's something, then we'll have to refer to that. Otherwise, we'll have to come to our own conclusion, in fact. ಏನು ಪಬ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಆಬ್ಜೆಕ್ಷನ್ ರೀಸನ್ಸ್ ಇಲ್ಲ ಇದಕ್ಕೆ 97. ಎಸ್. ಅಲ್ಲ, ಇದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಆಬ್ಜೆಕ್ಷನ್ ರೀಸನ್ಸ್ ಈ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ. Provide a measure of stability to the term of office of Adhyaksha and Upadhyaksha of Panchayat by stipulating that a resolution expressing want of confidence in Adhyaksha and Upadhyaksha of a Gram Panchayat shall not be moved within 1 year from the date of his election and within 1 year from the date of the last decision. So this is to provide a stability. This was in pursuance of a report submitted by Shri P.R. Nayak Committee.
Within 1 year, first come of idea.
From the date of his election.
First 15 months of the first 30 months, first 15
The
months.
date of his election ಅಂತ ಇದೆ.
First time ಬಂದಿದ್ದು 29 of 97 ಅಲ್ಲಿ.
ಅವಾಗ ಮೊದಲು ಆ ಒಂದು 1 year ಒಂದು ಇದ್ದಲ್ಲಿ ಇವಾಗ ವರ್ಷಿಪ್ ಸಾ ಇನ್ ದಿ ದಿಸ್ ಥಿಂಗ್ within the first 15 months ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Yes.
Within the first 30 months ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಆ 1 year ಅನ್ನೋದು ಇದ್ದಾಗ ಫಸ್ಟ್ 1 year ಅನ್ನೋದು ಇಲ್ಲಿ ಫಸ್ಟ್ ಅನ್ನೋದು ಇಲ್ಲಿ
Within 1 year from the date of his election. Of his election.
Of his election and
yes.
Here adondu additional word
within the first 15 months.
First 15.
Within first 15 months was introduced in 2015.
First
15 months ಅನ್ನೋದು
suppose he gets re-elected once again, then only it becomes irrelevant. After 30 months.
Why was this within the first introduced? And that was introduced by Act 2044 of 2015.
44 of 2015.
judgment ಮೇಲೆ there was an appeal. ಆಗಿದೆ appeal dismiss ಆಗಿದೆ.
In dismiss ಆಗಿರೋದು on a different ground. No confirmation of this finding, neither argue.
Yes. Appropriate application before the learned signature. Any reviewers filed? No reviewers filed. Anything else, Mr. Ali? Anything else?
The only point is, the object is to provide stability for a person who gets selected, understanding that whether he comes in this place or another place. Somebody resigns and another person comes also. Otherwise, it will lead to a situation where merely because another person can come to the place, he can be sent out even before the 30th. Any person who comes, he is entitled to occupy only for a period of 30 months. There again, another 30 months period is there. What the learned judge says is, though language is very clear, the learned judge makes that observation. The language is very clear that it is from the date of his election. I am taking a view that having regard to the consequences which will happen. This is what they say. Though would appear at first blush to be a correct literal interpretation, adoption of such an interpretation in the present fact would lead to absurdity, where the prohibition under 49 was thought to be made applicable where Adhyaksha is elected for the second time, consequent on the resignation zone. This interpretation is accepted. Then bar envisaged under second proviso to 49 would come into play whenever the Adhyaksha is elected. So the reasoning is that in a period of 5 years, 60 months.
That we got you.
Yeah, on that basis. So far as the language is very clear, language one has to go with the language unless there is a doubt with regard to language.
One other thing before Mr. Patil starts, we have held in another matter that the period of 30 months is not every time a person comes. Period of 30 months is from the date of the original election.
Yeah.
So only the remaining term.
There is also one.
So your remaining term will get over by 26/6/24. So ಅಷ್ಟೇ ಇರೋದು, ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇಲ್ಲ.
52 ಅಂತಾರೆ.
52.
In fact, a clear part of that judgment that actually has been referred. That reminder of the term, whoever gets selected is for the reminder of the term.
It has to be for reminder. It
51
can't be
is the kind
over
of vacancy.
last ಒಂದ್ ತಿಂಗಳ ಮುಂಚೆ ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನೊಂದು ಮಾಡಕ್ ಆಗಲ್ಲ. Because reservation is different. 52.
51 is the casual vacancy.
Yes. Yes.
Only a relevant problem.
Shall hold office so long as the Adhyaksha, Upadhyaksha member in whose place he has been elected.
Yes.
That is what.
So far as the prohibition of 15 months is concerned, the legislature is conscious of the fact that there is a casual vacancy and there is a regular vacancy. But even then, the legislature uses the word from the date of that election, not from the date of the first election. That being so, Lord, from the date of election, 15 months, it may happen or it may not happen. But this is not a case where where another person will not come at all. He will have to go out of the office, even otherwise also. 30 months, he will go out of the office. Suppose after.
In your case, only on 8th June 2024, it can be raised.
23.
15 months, 8 June. Yes, Mr. Patil.
Change that 30 months into 15 months ಮಾಡಿದ್ದಾರೆ. That has no bearing at all. The section remains the same. First term itself was 5 years. Term of the president was 5 years.
Your it is 30 months.
Then the restriction was half the term, that is 30 months was put. Initially 1 year was put, then it was made as 30 months half the term. Thereafter, the term itself was divided into two for the purpose of reservation. Now, the term of president could be 30 months. Thereafter, there will be a separate reservation, within that 30 months, the motion of no confidence will not be moved for 15 months is the first condition. Whether that condition would result in a situation like the present one. The earlier president resigns on 1/2/2023.
1/2 na 22/2 na.
Our resignation letter ಕೊಟ್ಟಿದ್ದು 1/2 ಕೊಟ್ಟರು ಅದು acceptance again ಅವ್ರದ್ದು ಲೆಟರ್ ಕೊಟ್ಟಿರೋದು 1/2 ರೆಸಿಗ್ನೇಷನ್ ಲೆಟರ್ ಅಂದ್ರೆ 18/4 ಗೆ ಅವ್ರ ಟರ್ಮ್ ಮುಗೀತಿತ್ತು.
ಅದಕ್ಕೆ ಮುಂಚೆ ಜಸ್ಟ್
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಟ್ಟು ಇವರು 7/3/2023 ಗೆ ಇವರು ಎಲೆಕ್ಟ್. In this way, there will be no motion of no confidence against any of them in the situation. It is specifically that has been taken note of, and court says you are elected for the remainder of the term. Therefore, first 15 months means first 15 months of the election.
one issue which
One
issue would be that the no confidence will be expressed against the Adhyaksha or Upadhyaksha.
Yes.
Not necessarily that it has to be expressed. It may be expressed. So if it is person specific of the person who is occupying the post.
It could be person specific.
So when it is a person specific,
The restriction that is being put is person specific, yes. On the very next day, we may say we don't like, we don't have confidence. But the act protects, some protection is sought to be given for it. Whether that protection should be in that manner. Otherwise, it is definitely.
distinction that we are looking at from what Mr. Arnoldi has argued and you have argued is that Adhyaksha or Upadhyaksha from his is not party based or anything. It is the Adhyaksha or Upadhyaksha in his personal, in his official capacity of that, and that is that person. So if there's a no confidence of the previous person, if it could not be moved, could it be moved against the next occupant? If suppose 15 months had lapsed, if we take your your submission into consideration, then on 27/12/21 it would have been by March 23.
March 23, ಅವರು resign
20th ಆಯ್ತು 20th ನಿಮ್ಮ ಆ ಸಬ್ಮಿಷನ್ ಬಿಟ್ಟು 23/2023 ವರೆಗೂ 15 months ಏನು nothing could have been moved.
Yes.
Now suppose this person has got elected on 7/3/2023 and we accept your submission, then on within 15 days from that date, on 22nd, no confidence could be moved.
Could be moved, yes.
If we accept your submission.
Please.
But we'll have to look at whether it is person specific or the post specific.
I submit person specific would not make a difference for this reason. The protection is given, person specific. If it were to be against a person, if he loses confidence on the very next day, it could have been moved, or it may not have been moved at all. If he is not, if he retains the confidence.
Can be that
Yes,
that protection
that is-
which was there
that-
cannot be
that-
there.
That in the context may not make difference for the reason. Because we kindly see somewhere this word has to be given some meaning. The first 15 months, it was not necessary to use that at all.
First.
Of his election. 15 months of his election was the appropriate word, and that was the word used when it was 1 year. 1 year from the date of his election. First 15 months, first 1 year, first 30 months is not something that was there. It was plain 1 year from the date of his election.
Yes.
Therefore, the court took the view. Of course, not that it could not have been another view, but this view was specifically that reminder of the term was all looked into and pointed out it has to be given some meaning. If it is to be given some meaning, and if it is a situation that you should not move, that restriction should not be taken to be an absurdity, that it will not be moved at all. If a situation can be created that no confidence cannot be moved at
If
all,
it can be, if there's a possibility of misuse, then we should not
Yes.
encourage it as well.
that's why the court has taken that view. In the normal course of the, I would respectfully submit as the things stand, it's a order that would be holds the field for the present.
If there's a possibility of misuse, like in this case, where your predecessor resigned on 22/2/23, just before 1 month before the 15 months. And now you get 15 months. By 15 months, you'll complete the entire 30 months tenure.
The objects behind this is, one person gets appointed, gets elected. Election means that the person members have confidence in it. Now, any process of expressing no confidence should not take place against that person. Lord, today they appoint, they elect somebody, tomorrow they will say, no, I have no confidence. That should not happen. That is the object of it, giving some kind of a protection. No confidence would arise where a person gets elected and thereafter the members lose confidence after seeing it, the working of that president to some certain extent of period. Now, the object behind is that any person who gets elected should have a fixed tenure of 15 months. It does not matter for the earlier person, because you have expressed confidence in this person, then elect that person. Then on the second day only, you will once again change your views. That is not permissible. Is the object of this providing the safeguard, not whether one can move no confidence or not, is the main, not the main criteria. Any person, otherwise you should not have elected him at all. Suppose you
Moving of no confidence does not mean that no confidence resolution is passed. It is a question of a safeguard that at least for some time there should be stability. So 15 months stability. If you succeed against no confidence, then you will continue.
Suppose I go, let us say, in a given case, I resign and go earlier. Then also no confidence can be moved. Those are circumstances not relevant.
It is left to your choice if you want to resign. They will probably be happy, or otherwise we don't know.
That are relevant for testing this proposition is that any person on whom you express confidence, let us say, Lord, on the last day somebody resigns, another person is appointed immediately after 1 month, because the earlier person's period is over, we will express no confidence. That is not how, Lord, it should be concerned. Otherwise, it will be a case where the members go on.
We are conscious of that. That's why we asked Mr. Patil that. But if there is a possibility of a misuse of this provision on that basis of 15 for 15, then this court will probably err on the cautious side on that aspect. And already that matter is, there is no particular reason to distinguish the judgment on the basis of the change of pro rata. It has happened. 5 years has become 30 months, 30 months have become 15 months. It's only pro rata. So, and thereafter, after 30 months, there will be a reservation, new election. So
that was in a case, 30 months was the prohibition period. 30 months.
That is
Total
because
period is 5 years. That is a
full
situation.
term.
But here is a situation where normally one person moves out after 30 months only.
It doesn't,
Want of confidence.
it doesn't change it much. It doesn't change it. Because there has to be a fresh election after 30 months on the basis of the new reservation which comes in.
No, maybe for reservation or otherwise. That is not found in this. Every election, there will be a change.
You have to look into that.
Kindly see.
Why 30 months is because of the reservation.
30 months. Now, what applies to in a given case where the entire 5 years period is over for half of the period, 2.5 years, nobody can move. No confidence would change a lot. The situation would change.
It won't change. It's only pro rata. There won't be anything left in this matter after we decide this issue. We can as well dispose of the matter. Hello. That AGA accepts notice for respondent number 1 and 2. Respondent number 3 are Jala. CH Jala. Jala Lanka Taluk Niva. Vijay Somyaji accepts notice for respondent number 3. 3. B. Tyagaraja has filed caveat for respondent number 4 and he accepts notice for respondent number 4. Notice to respondent number 5 to 23 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. Petitioner was elected as a member of the third respondent, Badlur Gram Panchayat, for the period 2020 to 2025 and declared to be a returning candidate on 27/12/2021. Subsequent thereto, election being held for the post of the president, stroke Adhyaksha, one Srimati Amida was elected to the said post on 18/1/2022. However, for various reasons, she resigned from the said post on 22 by submitted resignation letter dated 1/2/2023, which came to be accepted on 22/2/2023. Subsequent thereto, fresh elections having been held, the petitioner was elected to the post of the president on 7/3/2023. When was the no confidence motion? When was it?
Requisition is given on 18/10/23.
Requisition for no confidence motion having been tendered on 18/10. 18/10/2023. A meeting is now proposed to be held on 21/11/2023 at 11 a.m. for considering the said no confidence motion. It is agreed by same that the petitioner is before this court seeking for the aforesaid relief. Ashok Karnataka Learned Senior Counsel appearing for the petitioner would submit that the petitioner having assumed office of the president of the Gram Panchayat on 7/3/2023 in terms of the second proviso to section 49 of the Karnataka Gram so and so is protected for a period of 15 months from the date of his election when no such no confidence motion could be moved. His submission is that the earlier president being in office from 18/1/2022 to 22/23, the petitioner having now been elected, the petitioner being elected on 7/3/23, within a period of 9 months thereafter, 8 months thereafter, a no confidence motion has been moved, which is within the prohibitory period of 15 months. And as such, the second respondent ought not to have called for the meeting, ought not to have issued notice dated 4/11/2023, fixing the date of meeting as 21/11/2023. The petitioner having been elected on 7/3/2023 would indicate that all the members of the Gram Panchayat had confidence in the petitioner to function as a Adhyaksha by taking advantage of, by misinterpreting the second proviso to section 49, a no confidence motion has been moved, which is not sustainable in law. In this regard, he relies upon the decision of a coordinate bench of this court in ILR, reported in ILR 2019 Karnataka 2395, and submits. Relying and submits that the said decision, though prima facie appears to be against the petitioner, was rendered in a different situation where the term of office of the Adhyaksha was for a period of 5 years, and the prohibitory period was for a period of 30 months from moving a no confidence motion. In the present case, and it is in that background that the coordinate bench of this court came to a conclusion that if the prohibition is held to be considered from each time an election takes place, and each time election of the Adhyaksha takes place, then during the entire tenure of the panchayat, no motion for no confidence could be moved. This submits will not be applicable to the present case, since in the present case the term is for a period of 30 months and the period of prohibition is for a period of 15 months. And the term of office being for a period of 5 years, it would not entail any prohibition to be our submission. That is what it must. It would not amount to a prohibition during the entire term of the panchayat. On these grounds, we submit that the above petition is required to be allowed. Jaikumar S. Patil and Senior Counsel appearing for respond number 4 would submit that the decision of a coordinate bench of this court in C. Pushpa's case is equally applicable to the present case, inasmuch as what is being considered, what is to be considered is the date what is to be considered is the period calculated from within the first 15 months from the date of the election. And this would relate back to the date of the election of the first president, stroke Adhyaksha. And merely because the earlier president had resigned and a new president has taken over, it would not give rise to a further protection of 15 months. He submits that now the period during which the person can occupy the post of Adhyaksha has been reduced to 30 months, inasmuch as post the said 30 months, fresh elections would have to be held for the said post depending on the reservation policy of the state. Thus, the tenure of the Adhyaksha being limited to a period of 30 months, unless the said Adhyaksha satisfies the requirement of the second term and gets re-elected. In the event of the prohibition of 15 months being read as from the date on which even the second president got elected, would probably result in the said prohibition being applicable for the entire term of 30 months, which is what has been considered by coordinate bench in C. Pushpa's case, which would be applicable to the present case also. On these grounds, he submits that the above petition is required to be dismissed. Shri Ashok Kannadi, learned Senior Counsel for the petitioner, Shri Jaikumar S. Patil, learned Senior Counsel for respond number 4, peruse paper. The short question that would arise for consideration in the present matter is whether there is any change of circumstance by way of amendment to section 46 and section 49 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993, carried out in the year 1920, which would make the decision in C. Pushpa's case inapplicable to the present matter. Question mark. Section 46 and section 49, as they stood prior to 2020, are reproduced hereunder for easy reference. Section 46 and section 49, post amendment in the year 2020, is reproduced hereunder for easy reference. A comparison of both the above sections would indicate that it is only the period of 5 years of the term of the panchayat, term of the office of the Adhyaksha, which has been reduced to 30 months. The prohibition which was applicable prior to 2020 for moving a no confidence motion has been reduced from 30 months to 15 months. Both these aspects cannot be looked into in isolation. What this court would also have to look into is the reason why the term has been reduced from 5 years to 30 months, in as much as on account of the reservation provided under section 43 of the Karnataka Gram Swaraj and Panchayat Raj Act, Gram Swaraj Act, there will be 2 terms for every panchayat, and the post of the Adhyaksha and Upadhyaksha will be reserved as per the reservation policy for every term by rotation amongst all the panchayats. Thus, it is on account of the said amendment that further amendments have been carried out in section 46 and 49, restricting the term to a period of 30 months. When this is taken into consideration, the reasoning in C. Pushpa's case, which was applicable to the entire term of 5 years, would, in my considered opinion, be equally applicable to the reduced term of 30 months, since the reduction in the term and the reduction in the prohibition period is pro rata to the term of the panchayat, a term of the Adhyaksha in terms of section 43 of the Gram Swaraj Act. Thus, for the very reason, thus I find that there is no change in circumstances requiring a departure from the reasoning of a coordinate bench of this court in C. Pushpa's case, which would be equally applicable to the present case. As such, I pass the following order. As such, applying the principles laid on in C. Pushpa's case, I have the considered opinion that the petitioner would not be entitled to a further protection of 15 months from the date on which the petitioner assumed office, that is from 7/3/2023, but the prohibition of 15 months under the second proviso to section 49 would have to be taken into consideration from 27/12/2021, when the initial election occurred to the panchayat. Hence, I pass the following order. Writ petition stands dismissed. That would date back in terms of section 52.
First election of the Adhyaksha, 18/1/22.
But what would happen if we take that? We have dealt with another matter. If we take that into account, if the first meeting is held after 3 months, then second term or 3 months plus 2 months, 5 ದಿನ ಕಮ್ಮಿ ಆಗೋಗ್ಬಿಡುತ್ತೆ. Okay. Shivakumar, you're appearing for whom? The request of learned counsel for the petitioner relist on 11th December. Yes.
Owner Maila. Operating portion is discussed by the my property, but there is no party to the proceeding. Party ಮಾಡಿಲ್ಲ. ಅವರೇ ಯಾರ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ.
ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ?
ಆರ್ಡರ್ ಇಸ್ ಅನೆಕ್ಷರ್ ಜೆ ಮಹಿಳಾ ಎನ್ಒಸಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೊಡಬಹುದು ಅಂತ ಮಾಡಿದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು ಎಗೇನ್ಸ್ಟ್
ಏನ್ NOC ಕೊಡೋದು ಅಂತ?
ಎನ್ಒಸಿ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಅಂಡ್ ಅದರ್ಸ್.
In the suit, your opponent is residing in the premises. You don't want electricity to be.
NOC ಕೊಟ್ಟಿಗೆ ಮಾಡಿದ್ರು. ಸೂಟ್ ಈಸ್ ಪೆಂಡಿಂಗ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಸೂಟ್ ಈಸ್ ಡಿಫಾಲ್ಟ್. Subsequently, miscellaneous fine.
Whatever you succeed in the suit, you will be entitled. If you succeed in the suit, you will be entitled. Why do you want to deprive electricity of the person who is residing there?
This road, earlier at the next we settlement deed only 100 feet of road.
Now you are before us, agreed by no objection for electricity connection. ಅಷ್ಟೇ ಅಲ್ವಾ? ನಿಮ್ದು ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯೋ ಅದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡುತ್ತೆ.
ರೋಡ್ ಹೋಗೋಕೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ರೋಡ್ ಹೋಗೋಕೆ 100% ಸಾಕು.
ರೋಡ್ಗೆ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್
ಅಲ್ಲ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ಈ ಕಟ್ಟಡ ಅದಕ್ಕೆಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಕಟ್ಟಡ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ರೋಡ್ ಹೋಗೋ ಜಾಗದಲ್ಲಿ
ವಾಟ್ ಇಸ್ ಯುವರ್ ಸಬ್ಮಿಷನ್? ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ NOC ಅಂತ ಹೇಳಿದ್ರಿ. ರೋಡ್ ಎಲ್ಲಿಂದ ಬಂತು? ಹಾ,
ಸ್ವಲ್ಪ 100 feet ರೋಡ್ ಇದೆ. ನಾವು ಅದರ
ಅನೆಕ್ಷರ್ ಜೆ ಓದಿ ಏನು ಅಂತ ಹೇಳಿದ್ರು. ಇದು ಆಪರೇಟಿವ್
78 ಮೇಲ್ಬರು ಕಡಿಲು ಗ್ರಾಮದ ಗ್ರಾಮ ಜನತೆ ಹೆಸರಷ್ಟು ಸ್ಥಾಪಿತ ಹಾಲು 1990 ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು 90 ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು ಎಂದರೆ ಸಂಘದ ಉದ್ದೇಶ ಗ್ರಾಮ ರೈತಾಪಿ ಜನರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಅವರಿಗೆ ಅನುಕೂಲ ಒದಗಿಸಲು ಆಗಿತ್ತು. ಈ ದೃಷ್ಟಿಯಿಂದ ನೀರು ಕಡಿಲು ಗ್ರಾಮದ ಸಂಘದ ವತಿಯಿಂದ ಒಂದು DNC ಘಟಕ ಸ್ಥಾಪಿಸಲು ಮಂಜೂರಾಗಿದ್ದು ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಸಂಪೂರ್ಣ ಮುಗಿಸಲು ಸದರಿ ಕಟ್ಟಡಕ್ಕೆ ಅವಶ್ಯಕ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಮತ್ತು ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಸಾಮಾನ್ಯ ಪರವಾಗಿ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ಅರ್ಜಿಯಲ್ಲಿ ಸಂಘ ಕಟ್ಟಡದ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೇರಿದ್ದು ಸದರಿ ಕಟ್ಟಡ ಜಾಗವೇ ಆಗಲಿ ಅಥವಾ ಕಟ್ಟಡ ಆಗಲಿ ಬೇರೆ ಯಾರಿಗೂ ಸಹ ಸೇರಿದ್ದಲ್ಲ. ಸದರಿ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ಎದುರು ಪಂಚಾಯತಿ ಲೈಸೆನ್ಸ್ ಅನ್ನು ನೀಡಿದ್ದು, ಆದರೆ ಸದರಿ ಜಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕಟ್ಟಡ ಕಟ್ಟುವಾಗ ಕಡಿಲು ಗ್ರಾಮದ ನಾಗೇಗೌಡ ಗೌಡಯ್ಯ ನಂಜೇಗೌಡ ಸೀರೆಗಳನ್ನು ಹಾಲು ಉತ್ಪಾದಕ ಸಂಘದ ವಿರುದ್ಧ ತಮಗೆ ರಸ್ತೆ ತೊಂದರೆಯಾಗಿದೆ ಎಲ್ಲಿ ಈ ಸಿವಿಲ್ ನ್ಯಾಯದ ಹಸಿರು ದಾಳಿಯನ್ನು 107/19 ಪ್ರಕರಣವನ್ನು ನಿರ್ಬಂಧಕ್ಕಾಗಿ ದಾವ ಹೂಡಿದ್ದರು. ಆಗ ಕಟ್ಟಡ ಕಟ್ಟಬೇಕು ತಡೆಯಾಜ್ಞೆ ಕೋರಿದ್ದರು. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಸದರಿ ಗೌಡೇಗೌಡ ಗೌಡಯ್ಯನವರು ಹೇಳಿದ ತಡೆಯಾಜ್ಞೆ ತಿರುಗಿಸಿತ್ತು. ನಂತರ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ಮುಗಿದು ಮೇಲ್ಮನವಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿತ್ತು. ಅದಾದ ಮೇಲೆ ಗೌಡಯ್ಯನವರು ಸದರಿ ಪ್ರಕರಣ ನಡೆಸಿದೆ. ಇದರಿಂದ ಸಲ್ಲಿಸಿದ ಕೇವಲ ವಜಾಗಿರುತ್ತೆ. ತದನಂತರ ಮೇಲ್ಮನವಿಯನ್ನು ವಿದ್ಯುತ್ ಪಡೆಯಲು ನಿರೀಕ್ಷಣಾ ಪತ್ರ ಸಾಮಾನ್ಯ ಪರವಾನಗಿ ಸೇರಿದ ನಂತರ ಸದರಿ ಗೌಡೇಗೌಡ ಗೌಡಯ್ಯನು ತನ್ನ ವಜಾಗಳನ್ನು ಪುನಃ ಸ್ಥಾಪಿಸಬೇಕೆಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. ಸಭೆಯ ಯಾವುದೇ ಆದೇಶವಾಗಿಲ್ಲ. ಆದರೂ ಕೂಡ ನಿರೀಕ್ಷಣಾ ಪತ್ರ ಮತ್ತು ಪರವಾನಗಿ ನೀಡಲು ಸುಳ್ಳು ಅರ್ಜಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ದಾವನ್ನು ಎದುರು ಮಾಡಿ ಕಾನೂನು ಸಹಾಯ ಪಡೆದಿದ್ದು, ಕಾನೂನು ಸಹಾಯದ ನಿರೀಕ್ಷಣಾ ಪತ್ರ ಮತ್ತು ಪರವಾನಗಿ ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ ಎಂಬ ವಿಷಯ ಹೇಳಿದರೂ ಸಹ ಎದುರುಗಾರನ ಪಂಚಾಯತ್ ರಾಜಕೀಯ ದುರುದ್ದೇಶ ಅರ್ಜಿಗಳ ಸಂಘಕ್ಕೆ ನಿರೀಕ್ಷಣಾ ಪತ್ರ ನೀಡುವಂತೆ ಹಾಗೂ ಪರವಾನಗಿ ನೀಡುವಂತೆ ನಿರ್ಣಯಿಸಿಕೊಂಡಿದ್ದು, ಸದರಿ ನಿರ್ಣಯ ಕಾನೂನಿಗೆ ವಿರುದ್ಧವಾಗಿ ನಿರ್ಣಯ ವಜಾ ಆಗಲು ಯೋಚನೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಎದುರಾದ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಸದಸ್ಯರಿಗೆ ಸಂಬಂಧಿಸಿದ MICM 13/22 ನಾವು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಬೆಂಬಲಿಸಿ ನೀಡಿದ್ದು, ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ದಾವೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಪ್ರಕರಣ ದಾವೆ ಪರಿಶೀಲಿಸಿದಾಗ ಗೌಡೇಗೌಡ ಹೇಳಲಾಗಿದೆ. ನಂಜೇಗೌಡರ ಪರಿವಾರಗಳಿಗೆ ಸಿಎಕೆ ಮದ್ದೂರು ತಾಲೂಕಿನ ಜಿಲ್ಲಾ ಮತ್ತು ಅಧ್ಯಕ್ಷರು ಹಾಲು ಉತ್ಪಾದಕ ಕಡಿಲು ಗ್ರಾಮದ ಸಿಎಕೆ ಮದ್ದೂರು ತಾಲೂಕು ಮಂಡ್ಯ ತಿರುಗಾಡಿ ಸಮುದಾಯಕ್ಕೆ.
What is the suit for? 108.
Injection in page number annexure F.
You can't come in the way, Mr.
Permanent injection. Para number page number 69.
You dismiss your application here. That cannot be a ground. That cannot be a ground. It's a permanent injunction. Not even a declaratory suit. Injunction restraining from interfering.
ಇದರಲ್ಲಿ ಈಗ ನಾನು ಈಗ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಅವ್ರು ಹೋಗಿ ಬಿಡಲ್ಲ.
Suit decide. ಡಿಸೈಡ್ ಆಗತ್ತೆ, ಇಲ್ಲ ಆಗಲ್ಲ.
ನಮ್ಮ ಮೈ ಸಬ್ಮಿಷನ್ ಕಟ್ಟಡ ಕಟ್ಟಲಿ ಏನಿಲ್ಲ, ಬಟ್ ರೋಡ್ ಜಾಗ ಬಿಟ್ಟಿರುವಂತ ಕಟ್ಟಡ ಮಾಡ್ತಾರೆ. ಈಗ ತೊಂದರೆ ಆಗುತ್ತೆ. ರೋಡ್ ಇದೆ ಅಂದ್ರೆ there is no alternative.
That is not the purpose of this. That you have to come with a different petition for that. ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ರೋಡ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಬೇರೆ ಪೆಟಿಷನ್
ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು ಒಂದು ಮುಕ್ಕಾಲು ಗಂಟೆ ಅಧ್ಯಕ್ಷ ಅಂಗನವಾಡಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
That is a
C1 C1.
Shri G.J. Somyaji accepts notice for respond number 1 and 2. So, Padluvagilu milk production yard standing council error idara. Society. Issue notice to respond number 3 returnable by 19th December.
ನಾನು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ನಾನು ಎಲ್ಲ ಪ್ರೂವ್ ಮಾಡ್ತಿದ್ದೆ.
ನಮ್ಮ ಸ್ಮೂತ್ ಎಲ್ಲ ಅಲ್ಲಿ ಇದಿದೆ, ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Obstruction of the road of the
That you claim for, not here.
road ತೊಂದರೆ ಆಗುತ್ತೆ.
ಅದು next one. Raj. Devraj ಇಲ್ಲ. Ms. Devraj is not well. But he is. You are appearing, Ms. Somyaji? 2 and 3 ಹಾಕಿದ್ರಾ? B.J. Somyaji submit that he has appeared for respond number, filed wakalat for respond number 2 and 3. Registry is direct to show his name as such and delete the name of Shri M.S. Devraj as that appearing for respond. Yes. What is there to show that it is?
Rest of it concerned to my house place. There is no specific notification or circular issue with the government in this regard. Except the provisions of section 73. About the and
73 you have already.
I have already.
Yes.
Now my ambition is sample for the please. Not you have the Alexa. Yeah, it's a challenging. The PWD department has issued saying that the property belongs to PWD and it is under their control and that is the promotion. But I can understand very well. I am not here to see that my father's name should be or should be in the national. Cannot be to avoid unnecessary complication or with this regarding PWD property or whatever with the state concerned. Then now I am submitting my note. The board is in the I think around 6 meters of the even time. Village Panchayat limits the road border of the highest. Kindly peruse it.
Page number.
Page number 4. Not very rich, my God. Canada ladies. Raja Edgarge. Dakhal Raste Bugadiya Anchilinga. 6 meters per person. Gram Panchayat permitted. So now 6 meters one or 2 feet. I have no objection to make it to the village Panchayat road. For that, my lord, please.
Let village Panchayat pass the resolution to that effect.
Other tax.
But Denaru Madi, illi you can't have it.
You take it instead of one the order on the law, my lord, please. I never want to see that. My kindly page number 12 for
Yes.
11 is the village map. 11, I'll come to it. 12, my lord, please. I just submitted the regarding the circle name and architect plus roads. Top side, village. So for this village, the right side, this survey number, those 2 properties on the right side are belong to that late Gundappa, now is the son. Now, the left side, highway got to the
Konuru Road.
This road is village Panchayat. This is being maintained by village. This road is not to unnecessary problem, you call my house.
ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಹತ್ರನೇ ಆಗ್ತಿದೆ.
It is for the panchayat to decide, and if there is some problem, they will pass an order on that. But you can't have it on the national highway.
Now the panchayat order is there, not to put for this highway around, to put the name for this circle. Adrinda our order should not be disturbed there. E road ಗಾಕೋದು. Other side are objecting.
They have no jurisdiction over that circle, Mr. Vishwanath. That is a national highway. Panchayat cannot say we'll name anything that comes next to our village. A circle one ಮಾಡ್ಬಿಟ್ಟು ಒಂದು ಹೆಸರು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. 73 does not give them that power.
May read 70. My lord speaking. Once again.
ನೀವು 3 ಸತಿ ಓದಿದ್ರಿ.
No, my lord.
4ನೇ ಸತಿ ಓದಿ.
This my lord. My lord.
ಆಯ್ತು ಓದಿ.
But 73, my lord, read with 2+37 will speak something in the matter.
Yeah. 73.
73. Karnataka Gram Swaraj and Panchayat Raj Act. Powers to name streets and number buildings. The Gram Panchayat may cause a name to be given to any street and may also cause a number to be affixed to any building or part of the building and may from time to time cause such name and number to be altered. This word street, my lord, he explained in section 2, clause 37, my lord. The concept, the meaning of street is explained like this, my lord.
Yes.
Includes, street includes any highway, cause highway, bridge, viaduct, arch, road, land, footway, subway, court, alley, or riding path, or passage, whether a thoroughfare or not, and when there is a footway as well as carriageway in any street, the said term includes both. So the word highway is used.
Highway I'll use. We'll have to take
ಅಂದ್ರೆ
it
ಅದಕ್ಕೆ
in
ಹೋಗಿ
context.
ಹೆಸರು ಬಂದದ್ದು.
We'll have to take in context. Gram Swaraj Gram Panchayat can exercise powers under this act in the area coming within its jurisdiction. The National Highway is vested with the PWD.
It's not like that. This meaning is assigned. If the village limits jurisdiction, panchayat limits jurisdiction, if highway passes, I am not saying highway to put my name on it. For that circle only, suppose this Bellur circle and such things. Only that identification purpose, it's not for any, only identification of that circle it will be called as. Likewise.
PWD can do it. You persuade PWD. Him last time or there. If PWD wants to do it, let them do it.
Their concept.
Not Gram Panchayat. The state is opposing it. The state is saying no.
That's what.
You have,
For this, I have referred myself. For Gram Panchayat, there is an adjoining road, not highway road attached.
ನೀವು ಅದು ಮಾಡಿ ಆಮೇಲೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. ಇವಾಗ ಏನ್ ಮಾಡ್ತೀರಾ? ಇದು ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು ಅಂತೀರಾ ಏನು?
My humble submission. So far concerned to highway concerned, I will not insist also.
I can't.
Or I cannot ask for setting aside or quash annexure M, my lord. But the village panchayat resolution concerned. Resolution concerned may be remained as it is, only within their limits.
Nobody has challenged it.
That was challenged, but it was confirmed by the.
Executive officer.
That
order is there.
Nobody has challenged it before us.
That is not.
We are not. We can't quash it.
Please.
So
That is not to be quashed. That's only my humble submission.
it is not subject matter before us. Annexure M and N you have challenged.
Actually.
So we can only deal with that. There's no this one. So now what do you want? You want to withdraw this?
Actually, I have given a representation from the PWD to that engineer PWD to reconsider that representation.
They will consider that.
That
Without
will be made.
liberties,
But without that, because reason is that I have passed a resolution for that.
That has been confirmed.
73. Challenge before that executive officer by appeal that has been
You
confirmed.
respondentary.
That has not.
Without petition, order.
They have to check with that order. Sir, my liberty to that extent, my lord, I will permit it.
We are not expressing any opinion on the panchayat resolution, is what we can observe, that's it. After arguing for some time, learned counsel for the petitioner seeks permission to withdraw the above petition. Is so permitted, petition is dismissed as withdrawn. It is made clear that this court has not expressed any opinion on the merits of the matter or the resolution passed by the panchayat. We are not expressing any opinion on that because there are other proceedings pending. And they should not misinterpret this art. Our representation is there pending. So they should not misinterpret it there.
Private respondents are challenging the panchayat resolution.
Illi challenge agide.
We are challenging that.
Where have you challenged it? ಇವಾಗ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಇದೆಯಪ್ಪ ಹೇಳಿ. Mr. Counsel, the order of the EO you have not challenged. You have not challenged. There's an order passed upholding the panchayat resolution. You are not challenged. Where have you challenged it? You may be aggrieved by it. You are not challenged it. ನೀವು ಎಲ್ಲೂ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. If you want to, you can do that in their petition. You have to file a separate petition. Ishwara, Mr. Krishna, you are appearing in all the matters. Raghavan, you are appearing for the petitioner in all matters. Yes. Which one do you want us to take? Yes.
What is challenged before? Honorable Board are annexures A and annexure J. Annexure A, my lord, is at page 27, and can you come in the lord, not get it.
Page.
What is it, 26, my lord? Lord Bengaluru Mahanagara Palike, ward number.
Where are you reading? What are you reading?
26, my lord.
26.
At annexure A.
Yeah.
Annexures from the side. And I tell you what it should be in all the big petitions. Lord Bengaluru Mahanagara Palike, ward number 25, Paramavu Vyapti, ಸರ್ವೆ ನಂಬರ್ 8 ಮತ್ತು 20 ಬಿಬಿಎಂಪಿ ಖಾತಾ ಸಂಖ್ಯೆ 16 ಮಾನಿ ಬೈರತಿ ಆನೆ ಪರಮಾವು ವಾರ್ಡ್ ಸಂಖ್ಯೆಯಲ್ಲಿ ನೀವು ಮಂಜೂರಾತಿ ನಕ್ಷೆ ಪಡೆದು ವಾಣಿಜ್ಯ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿದ್ದು ನಾವು ಕಟ್ಟಡ ನಿರ್ಮಿಸುತ್ತಿರುವ ಸ್ಥಳದಲ್ಲಿ ಪ್ರಥಮ ಹಂತದ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವಿದ್ದು ಈ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವನ್ನು ಮುಚ್ಚಿ ತಮ್ಮ ಕಟ್ಟಡ ನಿರ್ಮಾಣದ ದಾಖಲೆಗಳನ್ನು ತಿಳಿಸಲಾಗಿದೆ. ಅಂಡ್ ದೆನ್ ದೇ ವಾಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೆಕ್ಷನ್ ನಂಬರ್ 126. ದಟ್ ಇಸ್ ನಾಟ್ ಎನ್ ಇಶ್ಯೂ. ನೌ ಕೈಂಡ್ಲಿ ಮೇಲ್ಕಂಡ ದಾಖಲೆಗಳನ್ನು ಈ ನೋಟಿಸ್ ತಲುಪಿದ 3 ದಿನಗಳೊಳಗಾಗಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ಪ್ರಸ್ತುತಪಡಿಸಬೇಕೆಂದು ನಿಮಗೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಸದರಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿತ್ತು. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಪ್ರಥಮ ಹಂತದ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವು ಹಾದು ಹೋಗಿತ್ತು. ಇಲ್ಲಿನ ಸ್ಥಳೀಯರು ರಾಜಕಾಲುವೆ ಮಾರ್ಗ ಮುಚ್ಚಿರುವ ಬಗ್ಗೆ ಆಕ್ರೋಶ ವ್ಯಕ್ತಪಟ್ಟಿತ್ತು. ಕಾಲುವೆ ಮಾರ್ಗವನ್ನು ಅಳತೆ ಮಾಡಲು ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಕೆಆರ್ ಬರಿಗೆ ಪತ್ರ ಬರೆಯಬೇಕು. ತಾತ್ಕಾಲಿಕವಾಗಿ ಸದರಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣವನ್ನು ಕೂಡಲೇ ಸಗತಿಗೊಳಿಸಲು ಈ ಮೂಲಕ ಪಡೆಯುತ್ತದೆ. This is what was question. And then Marot can be turned to, we replied to it Marot at page 86. Now can you turn to page 85 first, if I are can. This is Marot dated 17th of January 2022. They once again will not say that you're not. 3/17/1/2022 and the order.
Where is this property?
7/1/2022.
Where is this property located?
Varma. Near Mahaprabhu.
Bharati.
Bharati Khan.
Bharati Khan. He had appeared for this person in that relating to that property in another matter.
That is Shobha first. No, not that.
For this property, before the purchase by
by
the petitioner's vendor ಅನ್ಸುತ್ತೆ. Vendor joint developer. ಏನಿದೆ vendor joint developer?
Now, yeah, vendor. We have purchased the property, my lord. New supermarkets, my lord, is the demand.
We had appeared for your vendor in relation to that property.
I don't think that is very high, but I leave it, I mean, your lord.
We have no problem, but
Again problem.
justice must not only be done, but seem to be done alone.
Again problem. We have no. Sorry, we have no. Ultimately, my lord, the short question that arises is, when the Raj Kalve, which is alleged to be existing in the notices which are not shown in the master plan, can they say we rely upon a village man and then hold up the Raj?
In the matter that you appeared in and argued.
Yes. Yes, that's the only question. It's covered. And we are not being troubled. They don't give an occupant certificate. Waiting is complete. Hundreds of people who can be employed in the supermarket are not doing jobs. So they're not able to open it. Everything but investment in the base.
Plan was approved by?
The plan was approved by BBMP. The Russian gets it at 74.
BBMP is approved.
Yes, yes. And now, very interesting, there are office notice said that there is no Raj Kalve. Before the plan was signed. That is the interesting question. When we turn to page number 81.
Yes.
The right portion, my lord, is at page 51. The right portion is at page 83. Because Shivraj Motors, there were certain numbers, 8 ಮತ್ತು 20 ಖಾತೆ ಸಂತೋಷಿಸು ಅಮಾನಿ ಬೈರಾತಿ ಕಾಣೆ ಗ್ರಾಮ ಮಹಾದೇವಪುರ ವಲಯ ಬೆಂಗಳೂರು ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಸಂಬಂಧಿಸಿದೆ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತನ್ನು ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ಬೃಹತ್ ಮೀನುಗಾರಿಕೆ ಮಹಾದೇವಪುರ ವಿಭಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಮತ್ತು ಸಹಾಯಕ ಅಭಿಯಂತರರು ಅವರೊಂದಿಗೆ ಸ್ವತ್ತನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿರುತ್ತದೆ. ಗ್ರಾಮ ನಕ್ಷೆ ಮತ್ತು ಸರ್ವ ನಕ್ಷೆ ಅನ್ವಯ ಸದರಿ ಉತ್ತರ ಭಾಗದಲ್ಲಿ 4 ಕೊಳ ನಮೂದಾಗಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಇಡೀ RMP 2015 CDPಯಲ್ಲಿ ಯಾವುದೇ ನಾಳ ನಮೂದಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಪ್ರಸ್ತುತ ಭೌತಿಕವಾಗಿ ಸದರಿ ನಾಲಾ ಕೊಳ್ಳದ ಭಾಗದಲ್ಲಿ ರಸ್ತೆ ನಿರ್ಮಾಣಗೊಂಡಿರುತ್ತದೆ. ಈ ಕೊಳ್ಳದಿಂದ ವಾಟರ್ ಫೀಲ್ಡ್ ಕ್ಯಾನಲ್ ವ್ಯವಸಾಯಕ್ಕೆ ಅನುಗುಣವಾಗಿದ್ದು ಪ್ರದೇಶ ಅಭಿವೃದ್ಧಿ ಹೊಂದಿದಂತೆ ರಸ್ತೆಗಳು ಮತ್ತು ಕಟ್ಟಡಗಳು ನಿರ್ಮಾಣಗೊಂಡಂತೆ ಸ್ವಾಭಾವಿಕ ನಾಲಾ ಕೊಳ್ಳ ಹಾಳಿ ಸ್ಥಳದಲ್ಲಿ ವಸ್ತುಸ್ಥಿತಿಯನ್ನು ಕಳೆದುಕೊಂಡಿರುತ್ತದೆ ಮತ್ತು ಸ್ವಾಭಾವಿಕ ನಾಳ ಇರುವುದಿಲ್ಲವರಿಂದ ಬಫರ್ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ. ಹಾಗೂ ಪ್ರದೇಶದಲ್ಲಿ ನೀರು ಹರಿಯುವಿಕೆ ಅನುಗುಣವಾಗಿ ಕೃತಕ ಕಾಲುವೆ ನಿರ್ಮಾಣದ ಪ್ರಸ್ತಾವನೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಝೋನಲ್ ನಿಯಮಾವಳಿ ಅನ್ವಯ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ನೀಡಬಹುದಾಗಿದೆ ಎಂದು ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ವರದಿ ನೀಡಲಾಗಿದೆ. This is 18/4/2017 and the sanction plan was
ಅಭಿವಂತರು ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದು?
this one, this one was by ಮುಖ್ಯ ಅಭಿಯಂತರರು ನೀರುಗಾರಿ concerned department.
Storm water drain department.
Yes, our concerned department. And
In what department is this, Mr. Jagdishwara? ಭೂನೀಗ ಅಂದ್ರೆ ಏನಿದು?
ನೀರುಗಾಲುವೆ.
ಬೃಹತ್ ನೀರು ಗಾಲುವೆ.
And this, as your lordship will kindly see, my lord, this is dated 18th of March 18th of April 2017, and the plan in the instant case was sanctioned on 2nd February 2021. Your lordship gets it at page number 73. As if this is not enough, my lord, if your lordship will kindly also turn to page 84. They also issue a commencement check.
The measurement.
Yes. Prior to plan sanction, they do all the survey, inspection, come to a conclusion that there is no Rajkarya as per the RMP. Sanction the plan, give me a commencement certificate, and I've constructed the building. And now, my lord, I'm being troubled to say there is Rajkarya because some people are okay.
That was the first matter. What are the other two matters?
Lord, this is the first one. Now you have to kindly turn to the next one, my lord. That is WP number 21441 of 2022. Your lordship may kindly see, my lord, the Lord, kindly turn to next area. May I come, your lordship? For all the reasons that given, my lord. Kindly turn to page 29. ಪ್ರತಿವಾದಿ ಐದರವರ ಹಾಜರಿದ್ದು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ಸೋಲಿಸೋಕೆ ರಾಜಕಾರಿಗಳು ಒತ್ತುವರಿಯಾಗಿರುವುದಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಹಾಗೂ ಪ್ರತಿವಾದಿಯವರು ಹಾಜರಿದ್ದು ಮಾನ್ಯ ಪಾಲಿಕೆ ವಕೀಲರಾದ ಜಗದೀಶ್ ಅವರು ಕಾನೂನು ಕೋಶದ ಮುಖ್ಯಸ್ಥರಿಗೆ ಬರೆದಿರುವ ಪತ್ರವನ್ನು ಮುಗಿಸುತ್ತಾರೆ. ವಾದಿ ಪರವಾಗಿ ವಕೀಲರು ದೃಢೀಕರಿಸುವ ದಿನಾಂಕ ಸೋಲಿಸುವುದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆ ತೆಗೆದುಕೊಳ್ಳುತ್ತಾ ಕಾಲಾವಕಾಶ ಕೋರುತ್ತಾರೆ. ಅದರಂತ ಸದರಿ ಪ್ರಕಾರ ದಿನಾಂಕ ಸೋಲಿಸುವ ಮುಖ್ಯ ಮುಂದೂಡಲಾಯಿತು. Then kindly go over to next.
Vadi yaru Prativadi yaru. Vadi is a new supermarket.
Right. Vadi ante now.
Prativadi is the corporation.
But lordship may kindly now turn to page 30 minutes.
30?
30. The continuation of the order.
Yes.
Kindly turn to the last paragraph. ಪ್ರತಿವಾದಿಗಳು ಹಾಜರಿದ್ದು ಈಗಾಗಲೇ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಬೇಕಾದ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಸೂಚಿಸಲಾಗಿದೆ. ಹಾಗೂ ಮಳೆ ಬಂದ ಸಮಯದಲ್ಲಿ ಅಲ್ಲಿನ ಸಾರ್ವಜನಿಕರಿಗೆ ತುಂಬಾ ಕಷ್ಟವಾಗಿರುವುದರಿಂದ ಕಡತದಲ್ಲಿನ ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಸದರಿ ಪ್ರಕರಣ ಆದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದೆ ಕೋರಿರುತ್ತಾರೆ. ವಾದಿಕ ವಕೀಲರು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಮೂಪಟ್ಟು ಸೋಲಿಸಲು ಕೈಗೆತ್ತಲು ಕೋರಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ಕಡದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳು ಹಾಗೂ ವಾದಿ ಕೃತಿಗಳ ಮಂಡಿಗೆ ಸದರಿ ಆದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದೆ ಇದನ್ನ ಕಾರಣ. When the matter is pending before this honorable court, on the very issue as to whether there is a Rajkarya or not, and there is no Rajkarya, he can't proceed. Is the contention that was urged, and therefore, my lord, we find another repetition. This is again point. And then, my lord, there are two things. Kindly turn also to Annexure D. See the page 150, which was also questioned.
Yes.
Kindly see the second paragraph, if you watch the calendar. ಆದರೆ ನಂತರ ಉಲ್ಲೇಖ ಎರಡು ಜಂಟಿ ಸರ್ವೆ ನಕ್ಷೆಯಂತೆ ಸ್ವತ್ತಿನ ಪಕ್ಕದಲ್ಲಿರುವ ಹದ್ದಿಗೆ ಹಿಡಿದ ಹಳ್ಳದ ಸೋರಿಸೋ ವಿಸ್ತೀರ್ಣವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದಾಗಿ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಈ ರೀತಿಯಾಗಿ ಮಾಡಿರುವ ಒತ್ತುವರಿ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡದೆ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿ ಒತ್ತುವರಿಯ ಬಗ್ಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ನೀಡದೆ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ಮಾಡಿಕೊಂಡಿದ್ದು, ಈ ರೀತಿ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ಪಡೆದ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ಪ್ರತಿಯಲ್ಲಿನ ಕ್ರಮ ಸಂಖ್ಯೆ ಷರತ್ತಿನ ಪ್ರಕಾರ ನಕ್ಷೆ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಲು ಅವಕಾಶವಿದೆ. ಆದ್ದರಿಂದ ಈ ಪತ್ರ ತಿಳಿದ 3 ದಿನದಲ್ಲಿ ತಮ್ಮ ಸಮುದಾಯದಲ್ಲಿ ವಾಟ್ ಹ್ಯಾಪನ್ ಮಾಡೋ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಉಲ್ಲೇಖ ಎಲ್ಪಿ ನಂಬರ್ ಸೊ ಪ್ರಾದೇಶಿಕ ಭೂ ದಾಖಲೆಗಳ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಬೆಂಗಳೂರು ವಿಭಾಗ ಭೂಮಪಾನ ಕಂದಾಯ ವ್ಯವಸ್ಥೆ ಮತ್ತು ಭೂ ದಾಖಲೆಗಳ ಇಲಾಖೆ ಬೆಂಗಳೂರು, ಮಾನ್ಯ ಜಂಟಿ ನಿರ್ದೇಶಕ ನಗರ ಯೋಜನೆ ಉತ್ತರ ಬಿಬಿಎಂಪಿ ಮತ್ತು ಮಾನ್ಯ ಉಪನಿರ್ದೇಶಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ವಿಭಾಗ ಬೆಂಗಳೂರು ಸರ್ಕಾರದವರ ಜಂಟಿ ಸರ್ವೆ ನಕ್ಷೆ ದಿನಾಂಕ 13/6/2022. All these were subject matter to first question. This report also, if they are referring to Malone, as 13/6/2022, was all being considered by this court in the first writ petition, 370. I will also tell you.
Is there a interim order in the first matter?
Yes, yes, there is. There is.
What is the order?
The interim order is not to take any points from the exact wording. I know whether the interim order, I give you the exact wording. Order goes, I don't want to say something that is not fair. I want to wording. There is interim protection, I give you also the correct wording.
Did it prevent them from taking up the matter? Did it prevent them from taking up the matter?
You are also saying, you are also.
Operation of Annexure A is state.
Yes, operation of the order 27/1/2022 passed the responsibility and the state or petition proceed with construction according to sanction. Exactly what we have done. And you are now saying it was the occupant certificate. He says, no, I won't give you occupant certificate. That is the third writ petition.
What was the stage of construction on
It's all completed.
what was the stage on 27/1/22?
27/1. 27/1.
Yes, when
I will be able to answer your question directly immediately. Whatever it is, Lord, in fact, the order says I can proceed with the construction.
yes, you can proceed, but that will be subject to the
Of
report.
course, not.
That won't, just because it is complete,
My God, question is not whether the construction is in accordance with sanction. That is nobody's case, it is not.
Hmm.
Today, the narrow question is as to whether there is a Rajkalme or not. And on that basis, can the corporation?
what are the documents that you had submitted for plan sanction?
Document submitted for plan sanction?
Yes.
Those
Because this 3/1/4 guntas, is it B Karab, A Karab, or
It's something that it is best to the corporation, also to the government.
what is it classified as?
Something is a barren land, always best to the government.
What is it classified as? Adgidada. So, Adilla adike. Is it shown in the RTCs and where the
Yes.
conversion order? What does the conversion order say about this 3 and
Person is in respect of their property. By taking the plan and license by suppressing the tax mallards, they put up construction by encroachment of the world. That is the case of the respondent here.
is survey number? There's a particular survey number.
Yes.
ನಿಮ್ದು ಯಾವ ಖರಾಬ್ ಹೇಳ್ತಾ ಇದೀರೋ that is part of that survey number. That would have been reflected in the RTC.
RTC.
So if it is reflected in the RTC when the conversion happened, was this 3.5, 3/1/4 guntas converted or not converted?
But the land is not been converted.
So
Their land is different land. Adjacent to the Agricultural, their property that is not one side.
and if there's different land and it's adjacent, and there's no question at all.
See,
You
my
cannot
lord,
interfere with their property.
Madam, this is something totally new that they are saying. Now let us, I would request.
That was the report.
I would request, my lord, that we confine ourselves to the so-called notice that is issue. Where the categorical case is only one.
shall I take the report? What I should find it on my last.
Where is this 3/1/4 gunta?
No, it is part of our property which we have purchased. It is not in dispute.
It's
It is
part
a
of your
property in yes, Lord, it's the property which we have purchased. It is a property in respect of which there is a sanctioned plan. According to the corporation, the notice which was issued, which has been included in WP number 372A, the only case is that you are constructing on a Rajkalme. That's the only case.
Raj Kadwe and now Arla.
Again,
different.
whatever one they want to, if they announce claiming that it is not your property, then the entire complexion of the objection of the corporation changes. But that can't do it on the basis of,
If they do it, it is for your benefit.
that's it. But today the court is not doing what I'm saying.
If they do it, it is for your benefit.
That's right.
Then that whole thing goes.
What, it should go anyway to.
That's it, that will see. If 3/1/4 guntas, what is it classified as in the RTC, and as that is that also part of the
Sanction time. Answer to your which is yes.
part of the conversion, part of the kata, and part of the sanction?
Answer is yes.
And does that 3/1/4 been brought to the notice when the, because they are saying that it was suppressed and
No, no. No, not what they're saying, you know, can we go back to the notice? They are not arranging any submission. Please be kind enough to take the, that's why I wanted you not to.
Second petition.
9728. They can't change their stand like this. Let us be clear, my lord, as to what they want to say. Kindly see 3728. I'll tell you, Lord, kindly give me. Let us see the sequence of events. Please see. Actually,
28. Yes.
none of these are questions arise today in this petition with respect to submission again. ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾರ್ಡ್ ನಂಬರ್ ಸೊ ಕಟ್ಟಡ ರಚಿಸುತ್ತಿರುವ ಸ್ಥಳದಲ್ಲಿ ಪ್ರಥಮ ಹಂತದ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವಿದ್ದು ಈ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವನ್ನು ಮುಚ್ಚಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವುದಾಗಿ ಗೆದ್ದರಹಳ್ಳಿ ಗ್ರಾಮಸ್ಥರು ಈ ಕಚೇರಿಗೆ ದೂರನ್ನು ದಾಖಲಿಸಿತ್ತು. ಆದ್ದರಿಂದ ತಮ್ಮ ಕಟ್ಟಡ ನಿರ್ಮಾಣದ ದಾಖಲೆಗಳನ್ನು ಒದಗಿಸಲು ತಿಳಿಸಲಾಗಿದೆ. And then they want 1 to 6 all of which has been given to them. ಮೇಲ್ಕಂಡ ದಾಖಲೆಗಳಲ್ಲಿ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 3 ದಿನಗಳ ಒಳಗಾಗಿ ಈ ಕಚೇರಿಯಲ್ಲಿನ ಪ್ರಸ್ತುತ ಪಡೆಯಬೇಕೆಂದು ನಿಮಗೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಸದರಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿತ್ತು. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಪ್ರಥಮ ಹಂತದ ರಾಜಕಾಲುವೆ ಮಾರ್ಗವು ಹಾದುಕೊಂಡು ಇಲ್ಲಿನ ಸ್ಥಳೀಯರು ರಾಜಕಾಲುವೆ ಮಾರ್ಗ ಮುಚ್ಚಿರುವ ಬಗ್ಗೆ ಆಕ್ರೋಶ ವ್ಯಕ್ತಪಡಿಸಿತ್ತು. ಕಾಲುವೆ ಮಾರ್ಗವನ್ನು ಅಳತೆ ಮಾಡಲು ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಅವರು KR ಪುರಂರವರಿಗೆ ಪತ್ರ ಬರೆಯಲಿತ್ತು. ತಾತ್ಕಾಲಿಕವಾಗಿ ಸದರಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣವನ್ನು ಕೂಡಲೇ ಸ್ಥಗಿತಗೊಳಿಸಲು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಲಾಗಿದೆ. So if we are not able to this case, they stand this here. They say in the property where plan has been sanctioned so far you are concerned, there is a Rajkaluwe. Therefore, please stop. Now the question that arises therefore for your logic consideration is there or is there? Today, that is not even a question that arises in my respective submission because in an admitted position that there is no Rajkaluwe as per
By their own endorsement.
But I can show your logic in more than one place. Apart from the document they showed your logic, where they have admitted a statement of objections filed before this honorable court in the present petition that there is no Raj.
What does it say?
Well, please be kind enough to take the statement of objections that has been filed in the second petition number 21441.
1441.
Kindly see, my lord, the statement of objections in WP number 21441 of 2022. Your lordships are kind enough to turn to paragraph number 12.
Yes.
It is submitted that the alleged intention there did not exist any agricultural operations and the said area is fully developed did not mean that water bodies will be destroyed. In the said Rajkaluwe, road has been constructed by developing it as revenue site and as said Rajkaluwe is not shown in the RNP as well as the Google map. So for whatever reason, right or wrong, Rajkaluwe does not appear in the RNP. If Rajkaluwe does not appear in the RNP, even according to them, the law may not laid down by this honorable court is quite clear.
They themselves said you formed a road on the Rajkaluwe. Who formed that road? You have to take action against them.
And I can tell you, there are a number of big constructions that have come, they have not chosen to do anything there.
We'll come back to you. Just make the observation. Yes.
And then can you see a few more lights? As such, the boundaries have no relevance at all. At the time of Mahadevapura zonal map preparation also, it was not noticed about the Rajkaluwe. Due to the rains, the entire Bangalore metropolitan city has been flooded due to the blockage of rainwater. Since several residential buildings have come up over the Rajkaluwe, not several multi-story apartment buildings have come up. In view of the said prevailing circumstances and due to loss of lives, men and material, hardship to lakhs of citizens, this honorable court in WP numbers. So I directed the respondent to identify encroachments on stormwater drain and ordered to remove the same. While undertaking such survey, it was noticed about the encroachment over the Rajkaluwe and missing of Rajkaluwe in the entire public document, namely RMP, BPLP, zonal map and Google map, etc. In fact, there are various issues in support to preserve water quality. There is, of course, I don't think that And now, Lord, I just want to point out why is the second writ petition becomes the The logic alone, look at what happened. But I want to point out the logic. Not kindly turn to page 87 of the first page. We see page 87, which is dated 28/1/2022. This is my lord. In response to the letter dated 27/1/2022, with reference to the above subject, you are issuing the notice on 27/1/2022. We are submitting all the documents related to such. Our property not comes under Raj Kalwe as per our records. We already submitted those documents on 18/1/2022. Second time today, also we are submitting documents for your information, and that letter of 18/1/2022 is at page 86. That is my lord in response to the notice dated 17/1/2022. Yes. Then my lord, the lordship may kindly turn to then we find the petition my lord on 15/2/2022. And entry order was granted as your lordship succeed. Now there is an order that has been passed on 19/5/2022 in this writ petition. And I want your lordship so that your lordship have all the facts. Which it is dated 19th of May 2022. Which so in order sheet.
In order sheet.
This year, there is an order passed in the present.
Right again. 19/5.
Order my lord passed by his lordship Justice Natraj.
19/5.
2022.
Yes.
The dispute in this petition revolves around the question whether a Rajikan way runs near the property of the petitioner and whether the construction undertaken by the petitioner lies within the buffer zone as prescribed in the National Green Friday. Learned counsel for the petitioner submitted the master plan prepared by the BDA does not make any reference to Rajkalwe, while the learned HCGP would contain the Rajkalwe does run near the property of the petitioner, which is evident from the survey maps, which have evidentiary value, and the Rajkalwe is listed in the state one. It is seen from the revised master plan based on record with learned counsel for the petitioner that there is no reference to any Rajkalwe. However, since responding number 3 by way of reviewed order by Annexure A dated 27/1/2022 has filed, the Rajikalwe running near the property of the petitioner is closed by the petitioner. It is appropriate that the team comprising of the Joint Director of Land Record, Department of Survey and Land Record, Commissioner of BDA, and the Joint Director of Town Planning BBLP is constituted to verify the property in question to ascertain whether a Rajikalwe runs near the property of the petitioner and whether the buffer zone as prescribed under law is complied with while sanctioning the plan to permit the petitioner to conduct construction. This exercise shall be conducted by the case within a period of 2 weeks from today, and the report shall be given in the report by 15/6/2022. The team shall inspect the property of the petitioner with reference to the existing CDP, the survey map on 4/6/2022, and the report thereof will be placed before this court on 15/6/2022. London High Court Government Leader for respondent number 1 to 4 is directed to forthwith intimate the Joint Director Land Records, Department Land Records Survey, as well as Joint Director of Town Planning BBLP about this order. The district is directed to issue appropriate intimation to Commissioner BBA about this order. Construction that will be put up with the petitioner in the premises shall be registered the petitioner, and the petition cannot bring any. Now, after this order was the direction was issued, your lordship may kindly see below a survey was conducted on 4/6/2022. And the report was filed before this court on 20th of June 2022. This is the survey.
Was it filed?
It was filed by. It was filed along with the memo dated 22/6/2022 by the learned government official.
In which matter was it filed?
It was filed in 37/28. First matter, sir. Yes, that one. The honorable court, when it's ordered that so and so, and direct the joint direct of land records so and so. To ascertain as to whether Rajkal is the property and whether the buffer zone as prescribed is compliant with sanctioned plan. On behalf of the BDA so and so represent in compliance with the order, for the two houses are prepared and then they say what are the properties. And now, Lord, I will not cover. Can we turn to the logic can turn plot 2 that page page number in and proposed land use under one sketch accident.
Yes.
The logic of kind of but we are now concerned with property number 8 and 20. There is nothing to indicate that there is. Our property number is in Park Lane 8 and Park Lane 20. And there's a Bangalore road that goes. And what is in Crosswell? Here for the high tension. And now we also can look at the last page of this report. I'm sorry, I'm not able to do the page number. Can you see note number 5? ಮೇಲ್ಗಂಡ ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳ ಸೆಕೆಂಡರಿ ನಾಳ ಆಗಿರುತ್ತದೆ. So not ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳ is not anything different from a ಕಾಲುವೆ. ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳ ಸೆಕೆಂಡರಿ ನಾಳ ಆಗಿರುತ್ತದೆ ಎಂದು ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಬೃಹತ್ ಮೀನುಗಾರಿಕೆ SWD BPMP ರವರು ಸ್ಥಳದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. That's not what he was asked to do. ಸದರಿ ಹಳ್ಳಿ ಗಿಡದ ಹಳ್ಳಕ್ಕೆ ಉಪನಿರ್ದೇಶಕರು ನಗರ ಯೋಜನೆ ವಿಭಾಗ BDA ರವರು RMP 2015 ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳ ಮಧ್ಯಭಾಗದಿಂದ ಎರಡು ಕಡೆ 25 ಮೀಟರ್ ಕೊಪ್ಪರ್ ಬಲೆಯ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳದ ಮಧ್ಯಭಾಗದಿಂದ ಎರಡು ಕಡೆ 25 ಮೀಟರ್ ಕೊಪ್ಪರ್ ಬಲೆಯಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿ ಗುರುತಿಸಿದೆ. ಹಾಗೂ ನಕ್ಷೆಯಲ್ಲಿ ಈ ಬಣ್ಣ ಗೆರೆಯಿಂದ ಗುರುತಿಸಿದೆ. ನಗರ ಯೋಜನಾ ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರಪಾಲಿಕೆ ಬೆಂಗಳೂರು ಒತ್ತಿರುವ ಅರ್ಜಿದಾರ ಕಟ್ಟಡ ಅನುಮೋದಿತ ನಕ್ಷೆಯನ್ನು ಬರೆದಿದ್ದಾಗಿ ಮೇಲ್ಗಂಡ ಹತ್ತಿ ಗಿಡದ ಹಳ್ಳ ಮತ್ತು ಕೊಪ್ಪರ್ ಬೈಲಲ್ಲಿ ಅರ್ಜಿದಾರ ಕಟ್ಟಡ ಅನುಮೋದಿತ ನಕ್ಷೆಯಲ್ಲಿ ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. And now on that, when this report was pending consideration before this honorable court, the second proceedings.
So instead of Raj Kalwe, now they are saying it's secondary Raj.
There is no Kalwe at all. Whether it is Raj Kalwe.
Raj Kalwe will make it 50 meters. Secondary Kalwe will make it 25 meters.
Either of them is not found in the RMP. But what we have done nowadays, right? We have superimposed this very map on the Google map and see what is there. Identical, whatever has been shown, my lord, in this last page which you not saw, we have superimposed it on the Google map. Trying to see what is there, Manoj.
This blue color is the secondary Nala.
No, this blue color.
Huh?
Alleged Nala. And can you see what is there now in the Google map? That's a big road. destination. And if you also can see, my lord, that what is there in that dotted line, my lord, in that sketch, is the property where the subject matter is finished.
The brown hashed portion,
This one, the brown.
brown or red.
Sketch. Yes, in the survey, that is in both between.
As DEF
Yes.
HI.
Today, the case is not about encroachment. Today, the case is as to whether there is a Nara or not.
What is DEF HI D?
Muguru Kalbute. That will show the sketch itself, my lord. Survey can you see note number 3, madam? ABC ಅಕ್ಷರಗಳಲ್ಲಿ ಇರುವುದು ಒಂದು ಗಂಟೆ ವಿಸ್ತೀರ್ಣ ಹಾಗೂ PEJGHI ಅಕ್ಷರಗಳಿರುವ 1.5 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಪ್ರದೇಶದಲ್ಲಿ ಹತ್ತಿದಾರರು ಕಾಂಪೌಂಡ್ ನಿರ್ಮಿಸಿ ಹತ್ತಿಗಿಂತ ಉಳಿದ ಪ್ರದೇಶವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿದ್ದಾರೆ. Our contention was what is this report? What was he required to do? Look at it from the point of view of RNP and tell us. And to this report, we file objection, and then there is another order passed by this honorable.
Yes.
We also may see our objections to this report.
What is the order first?
Yes, I think. The second order has been passed. Kindly turn the order dated 13th of July 2022. Yes. Very good.
Yes.
Pursuant to the order dated 19th of May 2022, the team comprising of the Joint Director of Land Records, Department of Survey and Land Records, Commissioner BDA and the Joint Director of Town Planning, Growth, Bengaluru Mahanagar Palike had inspected the property and have submitted a report which indicates that the petitioner has encroached into the Raj Karve. Though this report is objected to the petitioner who contended that there is no encroachment to the Raj Karve. Northern side of the property of the petitioner, in order to ascertain the measurement of the property where the petitioner is undertaking instruction, Assistant Executive Engineer Auramavu is directed to physically measure the property claimed by the petitioner with reference to the plan sanction in favor of the petitioner and submit a report to this court. The Assistant Executive Engineer shall inspect the property on so and so it is open to petitioner to present. Pursuant to this, a second report was. That is on 3/8/2022. He was supposed to physically measure with reference to the sanction. Can you see what it is?
Eight.
3/8/2022. Memo dated 3/8/2022.
Yes.
Construction of commercial building at survey number so and so. As per direction of Honorable High Court of Karnataka, WC number so and so, site inspection report on 21/7/22. Building deviation details as shown below. Site deviation details on Nala and buffer zone. Building deviation details on Nala and buffer zone. But where is the reference to the sanction plan? And that was the direction given by this honorable court. And very interestingly, they suppressed one very important document. produce it. But that was not fair at all on the part of the public officer. So far as this court is concerned. And why am I saying so, my lord? Please look at our objections. He did verify with respect to the actual measurement and the sanction plan. He has made note of what is the measurement as per the sanction plan, what is the actual measurement as per construction. And that document is suppressed before the Honorable. But Commissioner, public officers,
But what?
look at our objection to this.
When was it filed?
It was filed on 12/8/2022.
Yes.
And revenue loss is kindly going to page 7. We have taken, this is a photograph of the notes that we had prepared at the inspection. And kindly see, my lord, this is exactly the sanction test. What he has shown in his report. But what is omitted is the actual measurement which is written by hand. Kindly, I'll just give you one indication. Please see, my lord, the sanction plan, and there it is 44.85, and the actual measurement is 44.60. Where is the deviation from the sanction? I have constructed less. And the sanction plan will not be available to the consideration in the main writ petition. Please see, my lord, the sanction plan. Exactly what is shown.
There's a road on 3 sides of the property.
Two sides.
Area left for road widening, road. Ennur Baglu road. More idave. The main road.
There are 2 roads, my lord. Balance portion of property. The balance portion of property.
Balance portion of Schedule A property is different.
Correct.
On top. Area left for road widening at the.
Beyond our property, area left for road. The road is wide marginal. One time, placing for your lordship's consideration is, how is all this relevant in the context of the notice that has been issued to me, which I challenged in the repetition? It is not the case that I am constructing a building in violation building plan. If that is so, what proceedings are different. It is not the case that I have enforced upon government head. If that is so, the proceedings are different. Today, the only objection raised to my activity on a property which is owned by me, in respect of which I have a sanction plan. I have a commencement certificate. UPSSC has granted permissions. The only contention is that there is a larger carway or a secondary carway running in the property. Therefore, you should not construct. The question already is there one. Admittedly, in the pleading before this honorable court, they admitted it is not there. And the document which overrides every other document is there. If in the RMP admittedly this is not there, I ask myself the question, what is the basis for that? Whatever other action they want to take, they take for it. That's a different issue. But on the basis that there is a Rajasthan and therefore the construction is banned, that cannot be done in a submission. Today, they can't widen this concept. That property doesn't belong to you, it belongs to corporation. The construction is in violation of the building plan, therefore it is valid. How is all that subject matter represented in petition? It is not represented. Therefore, we're not having regard to the law declared by this honorable court. In Shobha developer's case, it is now not the position in law that RMP supersedes every other term. And having regard to the statement of urgency is filed in the second writ petition, and in the third writ petition also they have said the same thing. RMP in law.
Was this sober developer's decision challenged on appeal?
But it was the writ appeal was dismissed from the total limiting. In fact, I'm sorry, Soba developers per se was not challenged. In another writ petition where Soba developers was referred, that was challenged before the division went, and that writ appeal was dismissed on the total limiting. Yes. So you will also look at this. I will first conclude. May I read it first? This was not in a case. Oh no, I read it. I now remember. They had even challenged Soba developers. Yes, Lord, I'm sorry. I forgot. Because dismissal is not a limitation, of course. Yes, I stand corrected. I'm sorry. But WP number 44277 of 2011 was Soba developers.
Thereafter, there is no challenge.
No.
This is attained finality.
Yes.
Yes.
This is all the short questions that are written for your last question.
Can have it Monday night, take judgment and
This is
that Malad Dematov informed earlier so that they can prepare well and make my submission. I'm not seeking time more than 3 days. He'll also have it by Monday by 2:30 or come to.
Heard Shri K.G. Raghavan, the senior counsel for the petitioners, for arguments of Shri N.R. Jagdishwara, the counsel for the corporation.
Yeah, especially if it's bench minority before in the first court. The bench is considered specifically for a matter minority, it's faster.
They have it on Wednesday. Because there are too many matters.
It is convenient, but I am sorry. I am requesting.
23rd at 2:30 PM for further hearing.
It's very. Interim orders earlier granted.
Interim orders earlier granted are extended.
Yes.
Extended. All of this will get adjourned now. There is no point in taking any matter.
Serial number 63, my lord. Yes. It is a case where
Other side here.
respondent has converted the site which is situated adjacent to my site as a burial ground.
Issue, we'll give you a short date. The other side is not here. The urgency is a short date. Not tomorrow. Tomorrow is. Because that there are a lot of parted matters posted tomorrow. All interim orders will get extended. Our court officer is the court.
Sudden factory ಮೇಡಮ್ ಈಸಿ ಮಾಡೋದ್ರಿಂದ ಸದಾ ಪಿಸಕರಲ್ಲ ಆಮೇಲೆ ವೆದರ್ ಬರುತ್ತೆ ಆಫ್ಟರ್
ಹೌದಾ?